disappears. Maintenance knows how to do it. It disappears.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is in re amendments to the rules regulating the Florida bar. Counsel, please proceed.
Yes. Good morning. May it please the court. I'm Andrew Sasso.
Please keep your voice up. We can't hear you at all. I can't hear you at all.
I think if you just maybe up a little bit.
Lean in.
Thank you.
Okay, that's great. Thank you. We're getting a little hard of hearing up here, so. Some of us.
Thank you. I'm here on behalf of the Florida Bar as a current member of the Board of Governors from the Sixth Circuit and immediate past chair of the Disciplinary Procedure Committee of the Board. I also would like to take a moment to introduce other attorneys that are here today to address the rules. We have first Floyd Fagley. He's a member of the Special Committee on Medical Lien Resolution, and he's here to address any comments or concerns regarding Rule 4-1.5. Lori Holcomb is here. She's the director of the Unlicensed Practice of Law for the Florida Bar. She's here to address any questions regarding Rule 1-310, 1-312, and 4-5.5. And finally, we have Ralph Artigler, who's immediate past chair of the Board of Legal Specialization and Education, and he's here to address questions regarding Rule 6-3.8. And I'm here as immediate past chair of DPC to address any questions regarding Rules 3-5.1, 3-5.2, 3-7.12, and 5-1.2. And I believe those are all the rules that the court has asked to be addressed today. And there's three other people I'd like to briefly introduce that are here in case we can't answer any questions that are addressed. And that's Kathy Bible, who's advertising counsel, lawyer regulation for the Florida Bar, Ken Marvin, director of lawyer regulations with the Florida Bar, and Elizabeth Clark Tarbert, ethics counsel for the Florida Bar. And we don't have any specific comments for the court, but we're here to answer any questions regarding any of these rules.
Who's going to start? I would like to address the two issues, and I think probably my colleagues will also. With regard, number one, to out-of-state lawyers practicing in Florida, and whether we believe that we can enforce and monitor that sufficiently. That's the first one. And then also I'd like to hear with regard to the workouts of liens and those things to be sure that we know where we are and that we're not letting the public be charged twice for work that should be done the first time around. And you know, we've read all the comments and those things, but those are just two general areas of concern that I have if there's no formal presentation.
Attorney Holcomb can address the first one, Justice, and Attorney Fagley the second issue.
Good morning. Your question is about the enforcement of the multi-jurisdictional practice of law rules. I'm guessing the 1-3.10.
Well, primarily the out-of-state lawyers that come in and the provision with regard to they can provide representation,
Right.
Disasters and all these kinds of things. And things are quite hectic during those periods of time.
Right.
And just that generally.
Okay, the disaster rule, it's also commonly known as the Katrina rule. That's the amendment to 1-3.12, and that would allow, under certain very limited circumstances, an attorney from another state to come into Florida to either provide services to Florida residents as part of a pro bono program, or to come to Florida and basically continue their law practice. If you'll recall with Katrina, a lot of the attorneys from New Orleans didn't have an office anymore, and several actually came here and wanted to continue representing their Louisiana clients. When you have someone under the 1-3.12, if they're coming into Florida to provide services to the Florida residents, they would have to do it as part of an organized pro bono program.
Yeah, I'm more concerned about how you monitor that lawyers coming in representing citizens for compensation and how that's monitored.
Okay, just the regular
determined.
4-5.5.
Right,
Okay,
right.
that would be the multi-jurisdictional practice of law rule. If they're coming in and they're going to court, they would have to file the motion to appear pro hoc vice, and a copy of that motion comes to the Florida bar. If they engage in any unethical conduct, and we actually have had just a few more inquiries than cases about it, then they are under the jurisdiction of the Florida bar and of this court. And if a complaint came in, they would be processed the same way a complaint would be processed against a bar member. The sanctions are a little bit different. We can, because they're treated as a member of the Florida bar, they can actually be suspended or disbarred. But really what happens is some sort of sanction would be entered, and then the state would take reciprocal discipline.
Again, we're
Okay, I'm
passing.
sorry.
Well, I'm concerned about lawyers from out of state. You're suggesting they can come in and represent Florida citizens
Correct.
on Florida disputes
Correct.
in Florida.
Correct.
Is what you're saying, and they have not passed the Florida bar. Who knows what they do know or do not know about Florida law. I consider it quite different with regard to citizens of their own state.
Right.
But this is so broad that it allows them to just come in just as though they're a Florida lawyer. Then is what it basically seems to me.
Are you talking about the disaster one or one of the existing rules?
Well, the entire area of foreign lawyers coming into Florida representing Florida citizens.
Okay. And you're correct. It would let them do that. And the safeguard is that they have been found competent by their home state. They've gone through a process where they've been licensed, et cetera, which is why it's limited to attorneys licensed in another country, in the United States, rather than a foreign country.
Louisiana is a civil code state, isn't it?
Yes, it is. And that was an issue that was actually discussed during Katrina. And it was ironic because Katrina happened shortly after this court adopted 4-5.5, which is the multi-jurisdictional practice of law rule. One way that rule acts as a safeguard is it only allows the attorney to come in on a limited and temporary basis. The Katrina rule, or the 1-3.12 amendment, also has safeguards because you would have to be doing it under an organized legal aid organization. So
Again,
you would
keep
have
going
some
back
control.
I don't think there's a pro bono issue. I'm not discussing
Okay.
that. I'm talking specifically for compensation.
But the 1-3.12 only allows you to do it pro bono. The 4-5.5 would allow you to do it for compensation, and in that rule, which was adopted by this court in 2006 or 2008, that is you can only do it on a limited and temporary basis.
Let me ask you this. I mean, I don't mean to be facetious about this, but why do we need this? We're going on 90,000 lawyers in the state of Florida. Florida, geographically, the way it is laid out, you could have a disaster like Katrina. In fact, Katrina went through Miami first before it hit Louisiana. And the rest of the state is not touched by it. And why can't the lawyers on the part of the state that are not affected by the disaster come in and help the areas that are affected? Why do we need out-of-state lawyers coming in?
They could, and you might not need the out-of-state lawyer. That's why the rule says that this court first has to make that determination. With Katrina, what happened was the Louisiana attorneys didn't have an office, and they needed to go someplace, and Pensacola is right there. And there was no way for them to actually establish an office in Florida to continue to assist their Louisiana clients.
Now that one I don't know, see, that's a little different. And we had a case, I think we have a case recently where somebody was using Florida, they were living in Florida, or they had an office in Florida, but they weren't practicing law out of Florida. That was just their address. Is that I mean, if you decide as an out-of-state resident lawyer, then you're practicing in California, you want to live in Florida.
Right.
Is that the practice of law in Florida if all you're doing is representing clients in another state?
Under 4-5.5, you cannot have an office or regular presence for the practice of law in Florida.
Even if you're not doing anything to represent, I mean, you have an office. Someone comes in who's a Florida resident and said, no, I can't represent you. I'm here as a Louisiana lawyer.
Under the existing rules, you could not do that. You cannot have an office here for the practice of law unless you're a member of the Florida bar. The amendment to 1-3.12 5.12, and then the counterpart, the little sentence in 4-5.5, would allow that person to come in here and have that office for the limited time of the disaster. So it would have allowed the Louisiana attorney to come to Florida and to provide services to their clients. This court actually let them do that. We kind of bent the 4-5.5 at the time.
Even seem, I'm not sure how we even have that authority to prevent somebody from living in Florida practicing law someplace else. But anyway, but you're saying that would solve that particular
Correct,
issue.
correct.
But they cannot practice, they cannot have Florida clients.
Correct.
Okay.
Correct.
We want to make that clear.
Correct. They would this would be so that if their law office was wiped out and their court system, again, it's called the Katrina rule. Think back, if we go back to Katrina, if there was no way that they could physically practice in their state, they could come to Florida and continue to serve their Louisiana clients or their Oklahoma clients or their Texas clients, wherever it would happen to be. And again, this court would first have to make that determination. Now, 13 states have adopted the rule. It's based on an ABA model rule. 16 states, including Florida, are considering the rule. And the safeguard is there, again, because the person who has the office here is not providing services to Florida residents or providing services or continuing their practice.
That comes back to the basic question, do we have enough people to monitor that kind of situation?
Well, I would think we would, because they would have to file a certificate, with the bar. It's just with anything else, we're totally complaint driven. If there was an issue, we would hear about it. And I really think that, again, because this court would first have to declare that there's this disaster and say attorneys from, Park City, Maryland can come to Florida and do this, there would be that control.
Well, under 1-3.12C, not the pro bono rule under subsection B, but under subsection C, what would prevent out-of-state lawyers coming in and practicing in Florida, representing clients in Florida?
We would hope that they wouldn't do that. I guess that's the best thing we can say. The rule allows them to come in and to represent their clients in their matters.
What it says is those legal services must arise out of and be reasonably related to that lawyer's practice of law in the jurisdiction. That's pretty broad. So if someone comes in and says, I'm a commercial litigator, and I did that in Louisiana, and that's what I'm doing in Florida, why wouldn't that be okay under that rule?
Because it's not related to the jurisdiction where they're licensed to practice. I suppose if a Florida resident, I'm sorry.
Doesn't this rule, I guess I'm a little concerned, because wouldn't this rule allow the lawyer, an out-of-state lawyer, Louisiana, for example, to represent clients who have now moved to Florida? I mean, they are no longer Louisiana residents. They've now moved to Florida. They're Florida residents now, and the lawyer from Louisiana can now represent them?
No, they could only represent their Louisiana clients for the temporary period of time that they're here while the disaster.
Well, who's here?
While the attorney is here, while the Louisiana attorney is here.
So if the client actually moves to Florida,
correct,
the Louisiana lawyer can no longer represent that person?
If it's a matter of Louisiana law and they're continuing the representation, if it's a matter of Florida law, no, they couldn't.
If it's if it's in the Louisiana courts, they can represent them.
Correct.
If it's in Florida courts, they cannot.
Correct.
And what I think Justice Pulse is asking you is that it's not, is this the model ABA rule?
Yes.
And it's clearly meant only to allow them to have an office here, not represent clients in Florida.
Correct.
Well, I'd suggest we can draft a lot better rule than that.
Well, this does track the ABA model rule, which again has been adopted by 13 states, and thankfully no one's had to use it. It came about right after Katrina, which was right after the multi-jurisdictional practice, and the ABA and the Conference of Chief Justices approved it. They endorsed the rule. Thankfully, no one's had to use it. Again, some states have declined it. It's been adopted by 13, considered by 16, and rejected by 6.
Well, the 6 that rejected, let's just see, because I'm still working on this idea that if they're not going to be representing Florida clients, their office is just a building.
Right.
They wouldn't be putting out the law offices of so-and-so licensed in Louisiana, because there's no reason to, because they're not attracting any Florida. They're just using a Florida resident. They're just using a space here.
Correct.
Why does that even need, if they're not formally establishing a law office, but they're just using an address in Florida for representing a client in another state, what if they had a winter residence? Why is that the practice of law here if they're not doing anything in terms of representing Florida citizens or disputes in Florida?
Because they're holding out, if they're here holding out as an attorney with a Florida address, they're holding out as a member of the Florida bar.
But they're really not. They're using that address, so when their certificate of service, they've got their address, when we get to email, it's going to be totally irrelevant where they are because they're able to do that electronically.
But under the existing rules and case law of this court, they cannot do it. If you want them to be able to do it, then the rule has to change. Under the existing rules of this court, it says an attorney cannot have an office or regular presence for the practice of law in Florida, period, unless you're a member of the Florida bar. So if you have an office or regular presence for the practice of law, now if you're in your home and you're snowbirding here for 3 months out of the year.
But isn't that statement ambiguous? I mean, I'm not looking at the text, but you said an office for the practice of law in Florida.
Right.
The whole point is it's not the practice of law in Florida. It's the practice of law somewhere else, remote from Florida.
Again, based on what this court has said and what the rule says, you can't have that office here. If you have a Florida address and you're holding out as an attorney, you have to be a member of the Florida bar, or you have to have an interstate practice.
I think basically what we're saying is if there's an attorney from another state practicing law in their home state, there wouldn't be a need for them to have an office in Florida. They would have a place that they would have space set up, but it wouldn't have law offices or telephones and things of that nature with Florida numbers on it.
Well, that's different.
Yeah.
Yeah, it's again, the example is if someone snowbirds, and we have it all the time. You're coming down to Florida for an extended vacation. You're coming down for 3 months out of the year. Your clients don't know you're here. They're still sending everything to Ohio. Your phone is ringing in Ohio. Your mail is going to Ohio. And Ohio is forwarding, your office is forwarding it to you. Your clients still think you're in Ohio. That's fine. We don't have a problem with that. When your clients know you're here and they're coming to you here in some form or another, under this court's existing rules, you need to be a member of the Florida bar or part of an interstate practice. And even then, you can only be here on a transitory basis. So, change the rule. If you want to allow it on a broader scale, then that's what you would need to do. This rule only does it in a very limited circumstance with disasters.
I have a question about another subject.
Okay.
Signing checks, trust account.
That would be Mr. Sasso.
Okay. And my question is really more the statement of a concern, which I'd like you to respond to. I'm concerned that this proposal with respect to the limitations on signing trust account checks could impose an undue burden on solo practitioners and put solo practitioners who might have, for instance, a real estate practice in a difficult position where they really can never go away while they've got business going forward in their offices. And what have the solo practitioners, what has the bar done to get input from solo practitioners to determine if this is going to impose such an undue burden on them?
We did carefully consider that issue, and it was a balance, of course. These rule proposals are published in the Florida Bar News, and we did get a few attorneys responding. The vast majority of attorneys that contacted me about it actually left comments such as they thought there already was a rule that prohibited anybody but lawyers from signing trust account checks. The few that did object to it, that real estate was a concern, and lawyers talked in terms of wanting to do real estate closings when they were out of town or weren't in the office. And so we can see that could be an inconvenience for some lawyers. However, when you balance that against the desire to put some more safeguards in place to protect clients and clients' funds, the board decided that this was the better way to go. I mean, there are a lot of things that lawyers can't delegate. You can't have somebody in your office, a non-lawyer, sign pleadings or attend depositions or go to hearings for you when you're out of town or on vacation. And we felt that this was very important. We also kind of balanced the fact that, you know, our trust accounting rules are very specific on things lawyers have to do. You have to have, you know, certain journals, you have to have ledger cards for each client, you have to reconcile on a monthly basis and on an annual basis. And it seemed odd that probably the most important thing is, you know, who's going to sign the check. We say anybody can do that. So again, it was a balance, but we thought that this was the best way to protect the clients, and you know, especially with all the options that are available. If you are out of town, obviously checks can be overnighted, back and forth. You know, if somebody wants to do a closing when they're out of town.
I mean, I know the world of real estate, a lot of use of paralegals. It is a little odd that somebody is earning a fee for representing someone in a closing, and they're not there to represent them at the closing. So, I mean, that would be I wouldn't be very sympathetic to that situation.
I agree, Justice Periante, and I think that was the sense of the Disciplinary Procedure Committee and the full board, that, you know, closings probably shouldn't go forward unless a lawyer is present to take care of those last-minute details, and to delegate all that responsibility, you know, right down to signing checks. And there have been a lot of cases, you know, that have come forward that are cited in the bar's response, where lawyers have done things where they've signed multiple checks in blank, and that's something else that would be prohibited, and left those with their office staff.
Were there any discussions on the middle ground with regard to, those are the two extremes, either nothing or then anybody can sign it? Were there any discussions somewhere in the middle that the committee would, you know, came up with thoughts or discussions, maybe that you have to have on file with the bar or something, who can, or whatever? Were there any middle grounds discussed or considered and rejected, and how about, could you address those?
Yes, Justice Lewis, those types of issues were discussed and debated quite a bit, you know, at committee level and at the board. And again, it was felt that this is an important enough issue that non-lawyers should not be signing trust account checks, just again, as they shouldn't be allowed to sign pleadings or attend hearings.
Couldn't you have as a middle ground that the person be bonded? This way, everybody's protected. If they steal the money, it's paid, and you know, they can go to prison and et cetera.
Yes, we did discuss bonding, and you know, problem arises there is it's hard to purchase a bond unless you know how much is in the account.
Well, that's on the lawyer, isn't it?
I guess you're suggesting that the rule would say you have to post a bond for the full amount of the assets in your trust account at all times.
Well, I mean, the reality is, I mean, people who steal money will steal it anyway, and whether they have a bond or not, they're going to do it. I mean, and it's happened. It's not as if once you put this in place, nobody will steal more money from trust accounts. I mean, because it's not the non-lawyer who does it, it's the lawyer that does it.
Right. No, there's no question this is not going to stop all theft from trust accounts. You know, we wish we could come up with a rule that would do that, but this is just an additional safeguard. And many states already have this rule in existence.
Let me ask you about the rule about permanent retirement, or, yeah. Well, if we have a rule that says that you have permanent retirement, why do you have a section that talks about being reinstated at some point or retaking the bar? I thought permanent meant you were out forever. That's section Rule 1-3.7. Is there some reason that we're allowing readmission if you're calling it permanent retirement? Yeah, you can answer if you have the answer to that.
Kenneth Marvin, Director of Lawyer Regulation. We do have a rule that allows retirement, and it allows the lawyer to be reinstated to active practice within 5 years.
Well, what about this permanent retirement? I thought this rule says this is permanent retirement. In my mind, that means that you would forever be barred from being a member of the Florida Bar, yet there's a provision that talks about coming back into the Florida Bar.
There shouldn't be for the permanent retirement part.
Okay.
That's permanent. That's agreed to. There have been a few different situations where Lawyers have received either a diversion or a minor misconduct with conditions. They haven't complied with those conditions. We've contacted them. The individuals have indicated they're no longer interested in practicing law in Florida. If they permanently retire, then the public protection would be preserved from those lawyers, and there wouldn't be any need for any future proceedings. We've had some situations where lawyers have been in advanced age, 50 years of practice with no discipline, and we've had discipline cases, minor discipline cases, but nonetheless, we've been able to resolve those cases with a permanent retirement and dismiss the discipline case. It just seems to be a way to protect the public without putting a blemish on an attorney who has practiced well for a long number of years.
I think Justice Quinn says that under 1-3.7E, it says, those who have been permanently retired shall not be reinstated under the rule and must be readmitted upon application to and approval by the Florida Board of Bar Examiners. So why is there a readmission procedure for those who are permanently retired?
We could eliminate that. That wouldn't be necessary. It would be like a permanent disbarment.
Yeah.
Okay.
I mean, if you use the word permanent, I assume
Right,
that's
that
what
would
it
still
means.
We need somebody to address the issue of the medical liens and whether there is an additional fee being charged. I think that was the other major area that was concerned.
Yes, my name is Floyd Fagley, and I was a member of the Special Committee on Medical Lien Resolution.
Now, when many of us practiced, liens and resolving liens were part of what you did as to earn your contingent fee. Now, is this going to allow or have a situation where a lawyer is going to be able to receive over and above the contingent fee for negotiating complex liens?
Not the attorney who had the primary representation in the personal injury matter. No, Your Honor.
But so somebody else, but so at the beginning, how do the lawyer is telling the client, if it's complex, I'll get my fee and you'll go to somebody else and you'll have to pay another fee for resolving the liens?
That's right, Your Honor. What the Special Committee, in reviewing this issue and studying this issue, determined that the personal injury attorney's primary responsibility is the pursuit of damages. The resolution of liens has become incredibly complex over the last decade or so.
But when you're negotiating an amount of the settlement, you know what is going on with the liens. In fact, you probably need to be negotiating those liens before you figure out whether you can settle something. I mean, somebody's got a $100,000 hospital lien, and you're going to be settling the case for $200,000. You're not going to be taking a 40% contingent fee on $200,000 until you find out, is that lien going to take up the rest of the money? So I'm very concerned that this is, can be misused to the disadvantage of the extreme, especially those that are very injured, and there's limited insurance coverage.
Limited insurance is often the reason why the case settles for the amount it does. The lien may be large in comparison to that
But what
policy
you're
limit.
saying is the lawyer can take a contingent fee on the entire amount of the settlement, which could be the policy limits, and then refer the lien work, which is going to be the major part of the person being able to recover anything, to someone else who will then charge an additional fee?
No, Your Honor. The primary attorney should take reasonable steps to negotiate the lien. If it's negotiable through normal standard negotiations, the primary attorney should do that. That's outlined in the comment.
What is happening now? I mean, I remember as I left the practice of law to go on the bench, these liens were becoming truly complex to handle. But my concern in reading the materials is there may be some lawyers out there who are settling the case and just turning the file over to the client and have the clients fend for themselves on these liens negotiations. Is that what is happening? Is that why we want on the contract the fact that the client should know who's going to negotiate this lien and who's not going to negotiate this lien?
That's part of the benefit of this. The rule provides that the primary attorney's responsibilities concerning liens is to be delineated in the contract.
But what if, okay, so a lawyer could actually contract himself or herself out of having to do this initially?
Not out of all responsibility. The responsibility to do standard negotiations, to take ordinary steps to resolve the lien. Some liens are easy. Some liens are, the lien holder does not have that great of a legal right, and they will work with the attorney. Those are the cases that the personal injury attorney should resolve those liens as part of his contingency fee.
Let's say you come in to see me on a personal injury case, and I'm the attorney, and I hand you a contract to sign, and the contract provides, in the provision, it says, I, the lawyer, will not handle any liens at all whatsoever. My job is to negotiate a settlement. In your case, I'll get $100,000 for you. I'll take my 33% or whatever it is, plus my cost. Here's your money. Go deal with this. Is that what?
No.
You cannot do that.
That's not what this rule contemplates. What this rule contemplates is...
Wait,
But it could have that effect, couldn't it?
That was ours, the same question. I mean, that could happen, though, right?
I don't
it all
believe
says
so.
You contract it up front as long as you make that contract.
In the comments, it talks about that the attorney on the primary matter should use best efforts to ascertain and resolve the lien.
But who's going to, see, the problem I have with it, who's going to determine how complex is? Maybe it's one of these advertisers who has some kind of a, gets all these cases in, and for them, everything's complex. I mean, I'm not, and so they go, I got Joe Blow, who's the, he does or she does the lien negotiation now, and I'm not even able to do this as a referral situation so that my client doesn't have to pay anything more. So who decides that? That whether it's ordinary or extraordinary?
Well, I guess the parties would have to, in their contract, would have to
And
do
how
that.
a person is severely injured, and we're having them sign this contract, and they have no idea, we don't even know how much insurance coverage there is. I mean, why not, I'm very concerned about this rule
But
and it being taken, people taking advantage of a client, unless we had some kind of court approval process that would say that if you're going to take away that responsibility, and it's different if it's bankruptcy. I mean, if we're talking about other issues, estate planning, bankruptcy, those things, nobody assumes that's covered within your contingent fee. But the resolution of liens is the single most critical factor, as I go back to, in determining whether the settlement you're about to reach can be a settlement that is fair for the client.
And it might even be determinative as to whether or not you would contact an attorney. If the liens are such that they morph the amount of the settlement, I mean, why would the client be interested in pursuing a claim to pay the liens?
That's very true. Oftentimes liens can encumber a large portion of the settlement. Let me talk about one case that was recently decided by the 11th Circuit Court of Appeals on September 29th, 2010. Bradley versus Sevillus. This is an example of how much work can go into resolving a lien and what the benefit can be to the client. This case involved the death of an individual in 2005, a wrongful death claim that settled for policy limits of $50,000 shortly thereafter, and Medicare claimed and demanded payment of $22,500 roughly. They refused to negotiate further down. They refused to cooperate. And through the 4 levels of administrative appeals with Medicare, one appeal to the Middle District of Florida, the plaintiff was not successful in reducing that lien. It took many, many years for that to occur. Eventually, in 2010, the 11th Circuit determined that the lien should only be asserted against and recovered from approximately $700 of the settlements. That is a tremendous result for the client.
How much attorney fee was paid for that? I mean, what does the client end up with? That's what concerns us, I believe, is that, you know, you pay the initial lawyer their third or 40% or whatever it is, depending on how whether it's settled or it goes to trial. And then you've got to pay another third of whatever is left to another lawyer to negotiate and reduce, and costs. To reduce that. I mean, that's what is of concern. The client ends up with nothing, basically.
We reviewed that issue in our committee, and we thought that the benefit of the reduction should inure to the client, and that client should be afforded the opportunity to hire the attorney who has the best skills to resolve the liens. Personal injury attorneys, they're great. They understand how to recover damages from liable parties. That's a very complex area, but there is a specialty, there is a benefit.
So why wouldn't we do this then? If there's a case where what is the most difficult legal work is the resolution of the lien, then in those cases, a lawyer who is only going to handle the personal injury case can only receive a 10% contingent fee or some reduced contingent fee, because sometimes, that's why it's contingent. Sometimes you luck out and you get this huge settlement and you get this amount of money. Other times, you've got to go to trial, it's on appeal, you've got to do all those things. We're not saying, well, that's the time that someone else bails because it's going to be really hard to earn your money. That's when you're earning your money, is when you're, so anyway, I'm not happy with this situation.
Well, the committee also reviewed that the resolution of the client's debts is not part of recovering the damages on behalf of the client.
What debts?
The liens.
The debts, that's what, if you've got a huge amount of medical, that's what enhances the value of the claim. It's not their debt, it's part of what you're recovering from the tortfeasor.
Well, that's true, but if the creditor isn't willing to work with you and reduce under normal circumstances, extraordinary steps are needed, and that this is a separate matter outside of the recovery of damages. Yes, it's an element of the damages, but oftentimes settlements are confined by policy limits and other considerations outside the value of the damages.
It seems as though that we have been away from the practice for a number of years, but the definition of what's complex and what's part of your obligation as a lawyer seems to me, I don't understand why that's changed over the years. I used to do this specifically because of the ERISA issues that used to come up, and never ever was there ever additional fees charged, and no one ever suggested that fighting with Medicaid, Medicare, the local hospital was something so complex that the lawyer responsible for the case, who earns a fee on the amount that may have to go back to the hospital, somehow was so complex that they couldn't handle it.
Over the last decade, lien holders have sold their debts to others to collect. And there are law firms and collections agencies that specialize.
But that doesn't change the nature of the lien, does it? It is just a lien that they've transferred to someone else for value.
It's changed the ability of the plaintiff to negotiate under.
What you're saying, willingness to settle it.
Willingness to settle, yes.
Okay, it doesn't make it complex. It just makes a recalcitrant opponent that you're dealing with.
It has also caused these ERISA plans to strengthen their language to make them draconian in their recovery rights.
Well, but again, okay. We're communicating. That's all right. I understand. We don't shoot messengers. We're just trying to get to the bottom of.
Please don't.
Yeah, we're trying to get to the bottom of something that seems like that there's something wrong with this. This is just not quite right yet.
I mean, did you look at alternatives such as, again, getting in those situations that if they're not going to negotiate a lien after it gets complex, that their contingent fee would be reduced then to, again, 10% or 15%, something much smaller court intervention to see if this is truly one of these an extraordinary situation, something that would protect the client? Was that any other options considered? Because again, what you're saying is this is going to mostly be a big concern in a policy limits case, but in those cases, then the lawyer shouldn't be taking the full amount of the contingent fee because they haven't had to do too much. They got the $100,000 because their client had $1 million of medical bills. and yet we're not, so was that looked at?
We looked at alternatives. We reviewed this matter extensively. There were both plaintiffs and defendant, or attorneys who represented both sides on the committee.
How about the victims? Did they weigh in?
No, they did not, but we did have...
I mean, the defense lawyers, what do they care?
We did have one lien holder who showed up and protested the idea that specialists could be involved and be paid for their services. We looked at these options. We also looked at what other states are doing. Ohio Bar Association has endorsed this. New York City Bar Association has issued an opinion allowing this. They see the value in the service, and they believe that service should be.
But it seems to me the client ends up with nothing in this kind of situation, where you've got one lawyer doing this, and then you go to the other one to negotiate, and it just does not seem like a workable solution to me.
Would the client prefer to pay the full lien and get nothing, or hire someone who can reduce their debt and receive something?
But my problem is the lawyer is in a position to have more knowledge about these lien situations going in. I mean, wouldn't you think more so than the client? You get the bills, et cetera. You say, okay, if we recover, this is going to be a problem. So you might just receive this amount, and then the person decides whether they want to pursue the claim or not. You might end up having a negative balance.
The personal injury attorney should be ascertaining the liens that are out there, keeping up with it.
So should we let him just out? Just say you sign this contract and I don't have to worry about this anymore?
No, we should not.
Okay.
And the rule doesn't contemplate that attorneys will be doing that. In fact, the comments discuss that the attorney should take steps to ascertain and negotiate liens that are negotiable, and do that work. It's the extraordinary, difficult cases where the client can benefit from an increased net recovery that it is possible to bring in others to help.
All right. We thank you. We've gone over about 18 minutes. I think we've probably exhausted that for now. So we'll now go to Mr. Chinaris.
May it please the court, my name is Tim Chinaris. I'm a Florida Bar member from Montgomery, Alabama, and I am here to speak against the bar's proposed rule 5-1.2D concerning signing trust account checks. I would like to, if I may, briefly address some of the comments that the court has had about this and the questions. As I pointed out in my comments, I do think that this would impose an undue burden on solo practitioners and lawyers in small firms. The court asked about the issue of input from people that might be affected. In addition to the publication in the Bar News, I contacted the Bar's General Practice Solo and Small Firms section, and at their September meeting, all of the members of the Executive Council who were present voted to support the position that I am advocating to the Bar. So I think they are in favor of that.
Yeah, Mr. Chinaris, what about that was suggested by Justice Perry, some kind of bonding situation? Because anecdotally, I haven't counted exactly with precision, most trust account problem cases are not from the larger firms that have lawyers watching one another, but they tend to be the smaller firms. So what would be the problem? I guess it's an additional cost, you would say, to do business, but to protect the public and to accomplish the same goal. Certainly, we understand it's a laudable goal that the bar is trying to accomplish. Certainly. And that why not some kind of bonding? If it becomes a common kind of requirement, one would hope that premiums would be competitive. And what's wrong with that idea?
Well, I would agree that I think that is something that is acceptable. From my standpoint, I think it would then give the lawyers who want to take advantage of the flexibility of having a trusted non-lawyer employee sign on trust account checks, they would have a way to do that if they chose to do it. And I think it's certainly prudent to bond the employees who would be in that position anyway.
Yeah, probably
and the fact
if you don't have the rule, it would be a smart thing to do.
Right, and you had asked about a middle ground, and I think the middle ground really is one that is expressed currently by the Bar's Professional Ethics Committee when they first considered this in 1964 and again in 1987, where they concluded that it is appropriate to have a trusted non-lawyer employee, not somebody outside the firm, draw checks on the trust account upon proper authorization and under appropriate supervision, and perhaps the bonding aspect is one.
I mean, that because we had that in the case, that 1964 ethics opinion, I think, to me, I was surprised to learn that we were allowing, or under our current rules, non-lawyers could sign trust account checks. Now, in the small lawyer situation, do we have an idea per month of how many trust account checks are actually by an average practitioner being signed?
I certainly don't, Your Honor. I would imagine it is not a real pervasive practice, because many lawyers have said the same thing to me, that they weren't even aware that this was an option.
Okay, so now we're really going from something where most lawyers assume they have to sign their checks. You're a solo practitioner, you just settled a personal injury case, the settlement statement comes, you sign the 5 checks that you need to sign. And I don't want to be, again, just as we heard with the last situation, I don't want to be, try to understand that a busy solo practitioner, I'm trying to understand how many checks a month in a trust account check. We're not talking about operating account, we're talking about trust account. How many trust account checks are being signed that this is such an onerous requirement?
I don't think it's the amount, Your Honor. It's the fact that a lawyer who has a sole practice can't be in 2 places at once.
And where are the 2 places?
Well, somebody might be in court, and there might be a real estate closing. Real estate closings were mentioned, and that, I think, gives the opportunity to point out that this rule really is inconsistent with some of the other rules that the bar has with respect to trust accounts. For example, there are ethics opinions that say a non-lawyer may conduct real estate closings with the lawyer available by telephone.
Well, why can't you do those? When I've gone to these kinds of things, you could do these checks in advance. You sit down and you figure out who gets what in these transactions. You do the checks. You go to the closing with the checks already made out to the people that you need to make them out to in the amounts you need to make them out. So what is the real problem there?
I think that is the common situation, but of course something may change at the closing and somebody needs to draw a check and the lawyer is out of town, which is allowed under the ethics opinions.
Again, we're, as Justice Labarga mentioned, we're over 90,000 lawyers. I don't know how many we'll be swearing in today. And some of the newer lawyers are not able to be employed, so they're hanging out a shingle. I'm sure they'd be thrilled to have some money in their trust account to be able to sign. I'm just concerned that what we're sending out is a signal that in the past, everyone assumed you have to sign it. Now we're saying you really don't. They have to be a trusted employee. So other than a real estate transaction, what other situation would present something that might be unduly burdensome for a lawyer who has all these other restrictions on trust accounts?
Well, I don't think it would arise every day, but certainly a situation where maybe a lawyer's in court or out of town taking a deposition, and as we were talking about trying to deal with our clients, a client comes in and a matter's been settled unexpectedly, the money's available, and the client really needs the money. And instead of having to wait a week for the lawyer to get back, somebody who's perhaps bonded, authorized, signatory on the trust account, as somebody who's worked for the lawyer for 25 years, could cut that $10,000 check to the client. I think it's a matter of courtesy to the client.
So we would have to let it go back to the bar if there was to be this bonding alternative, to figure out how the wording would be for that.
Certainly, and I would just point out one more rule, if I may. The rule dealing with trust account reconciliations is not really a personal rule with respect to the lawyer. Another example of inconsistency, it points out that the various trust account reconciliations and procedures, it starts out the lawyer shall cause to be made monthly. So the lawyer may delegate those. I think it would seem inconsistent to require the lawyer to sign the checks, but at the same time can delegate everything else relating to the trust account. So
what you're suggesting, I take it, is we just keep going under our present ethics opinion, which provides that an office manager can sign a check, but the lawyer understands that he or she is ultimately responsible for anything that happens.
Yes, Your Honor. I would agree with that, and I looked at the cases cited by the bar and other cases, and I really found no case that I thought would have had a different result if this rule had been in place.
But let me ask you this.
But we do have cases where lawyers say, that was my office manager who signed those checks and did that. If it's the lawyer who is signing the check, we know we can hold that lawyer's foot to the fire because the lawyer actually signed that check.
Well, and as you do when anybody else signs a check as well.
Well, maybe we ought to have all trust accounts bonded. I mean, we have, again, biggest problem is lawyers stealing from the trust account, not necessarily. I mean, we did have a case with somebody who was not even an employee of the person, of the lawyer, but...
So I think in that case, the Hines case, this court made the appropriate distinction between an employee who somebody can control and supervise and a stranger, as in that case. Thank you.
Thank you very much. We thank all of you for your presentations today. We appreciate your argument. We now move to the second case on today's docket, the State of Florida versus John McMahon.
May it please the court, my name is Helen Viz with the Office of the Attorney General, and together with Janine Germanowitz, excuse me, I represent the petitioner, the state of Florida. The state respectfully requests this court quash the decision of the 4th District Court of Appeal below and expressly recognize the state has the right to appeal pursuant to 924.07, an illegal sentence entered as the result of sham sentencing proceedings.
Let me ask you, let's go back for a second, because your initial premise is that the court, in this particular case, initiated the dialogue. Is that correct?
Yes, Your Honor, not just initiated, but far overstepped the bounds of a neutral.
I disagree with you, and here's why. I have a transcript of the entire proceedings, and again, in considering these type of situations, one needs to consider the setting in which this occurred. This is a criminal trial judge, and he's probably got 3 public defenders in the courtroom. He has 3 state attorneys in the courtroom, a bunch of prisoners in the jury box, packed courtroom, and he's trying to move cases along the docket. And the whole thing started with defense lawyer, Mr. Lewis. Judge, good morning. Judge, I have John McMahon, who is on page 4 of your docket. The court, what are you doing on Mr. McMahon? What are you doing on Mr. McMahon? Then the defense, it basically says, Your Honor, may I approach? Yes. On the new case, the state now notices on habitual offender. That's the prosecutor. Then the defense lawyer says, we are very hopeful to resolve this case this morning. This is a defense lawyer. We are very hopeful to resolve this case this morning. The court, that might be a good idea if you did. Defense lawyer, that is what I'm thinking. He scores 18 months at the bottom. Judge, I think with one rock case or something, cocaine case, and the grand theft case is he had somebody else in the car who picked up an old power washer that I seriously doubt was worth more than $100. So he's making his pitch to the judge as to just how a nothing case this was. The judge, state what you're looking for. What kind of priors does he have? He tells them what the priors are. And the court says he scores 18 months. And at that point in time, he said, you can have the bottom of the guidelines today. I won't habitualize him if he wants that today. That's where the 4th DCA began, the colloquy. Now, I don't see that as the court initiating this. I see that as a defense lawyer initiating this plea negotiation.
Your Honor, even if it was a situation where you would say, although the state began with, we want 15 years, that's what, here's the notice of the habitual offender, our intent to invoke. That's what the state was saying. We want 15 years. Defense counsel came back with, we kind of like 18 months.
Okay.
That's not addressing the question that Justice Labarga has presented you, and that is the fundamental question, as I agree with him. Who initiated this discussion? And that's what you need to address. Please, would you address his question?
Yes, Your Honor. Okay, the state will agree that defense counsel did begin the colloquy by saying, we would like to settle. The state will agree. He did say we would like to settle.
It's hard for you not to agree. It's like, it's right in there, and it's right in there. And why wouldn't the state, see, if we're here on a false premise, which is that the judge didn't initiate this, that the defense lawyer, as Justice Labarga went through, was initiating it, what are we doing here on this case?
Your Honor, we're not here on a false premise. We're here on the premise that a trial court may not enter into a plea, not just negotiations. The trial court in this case entered into the plea with the defendant over the objection of the state. The trial court
Warner,
stepped...
We said in Warner that is exactly what a judge is allowed to do. Warner does not require that both the state and defense agree to the negotiations. Only one party needs to.
Your Honor, I believe Warner does not hold that the state is completely left out of the contract negotiation for a plea. That's precisely what happened here. In Warner, this court said, we recognize one half step, as it was discussed in oral argument, away from a complete prohibition against trial court's participation. We recognize a trial court may discuss plea negotiations if a party begins that plea. Should this court determine that in this case, Mr. Lewis's statement, we would like to resolve this matter, was enough to invite the trial court to then become part of the plea negotiations, it certainly was not appropriate for the trial court at that point to say, my offer to you right now, 18 months, take it or leave it. State, but we object, Your Honor.
We don't get to decide the issue of whether this complied with Warner or not, because the first question is, which is why we're here, is this an illegal sentence? The state agrees, does it not, that 18 months was at the bottom of the guidelines, was it within the guidelines?
We conceded that below, yes, Your Honor.
So it's a legal sentence. You don't have, unless you find another hook to be able to appeal what happened, the appeal was correctly dismissed by the 4th District. So we don't get into, well, Warner should it be, expanded, contracted, changed. The only issue is was it a legal sentence or is it illegal? And you said something at the beginning that really concerned me. You said this was a sham sentencing proceeding. What do you mean by that?
What I mean was that a plea negotiation must, of necessity, involve the assistant state attorney and the defendant. In this case, this plea negotiation was between the trial court and the defendant. The assistant state attorney at no time participated in this plea negotiation, objected strenuously 3 times, even after the trial judge said, well, assistant state attorney, you agree this is within the guidelines.
See,
yes,
I
Your Honor.
guess that's a plea that's between the state and the defendant. The judge either approves or doesn't. A plea, as Justice Labarga was saying, as Justice Lewis said, that involves somebody asking the judge to consider a sentence if in exchange for them pleading today or doing something, not dropping any charges because that would involve the state, is what Warner talks about. I'm having a hard time, and the other thing about Warner I reread is that the rule was really crafted to minimize the potential coercive effect on the defendant. It wasn't really there to protect the state.
And Your Honor, that's what we're arguing in our brief. We have an obligation to protect the victims of crime, to protect the citizens of the state of Florida. That's precisely what this trial judge turned a blind eye to.
In connection with that, let me ask you to address this issue about the habitual offender status, because it seems to me what you really, the objection you actually made in the trial court is, hey, we are entitled to have a hearing on our motion to habitualize this offender, and the trial judge just gave that totally short shrift. The trial judge totally ignored, am I right, the statutory requirements for the judge to conduct a hearing on that and to make findings if the trial judge was not going to impose a habitual offender sentence, and to find that was, what's the standard? You tell me. And the trial court just did not do that. Now, isn't that an independent basis for your appeal?
Yes, Your Honor. We would argue, in fact, what happened here was that from the very beginning of this sentencing hearing, this train got off the neutrality track. This judge began by saying, my offer to you today is this, accept it, and then went on as the state continued objecting. But, Your Honor, we're asking for 15 years. We have the right to.
If that's the point that we ought to be addressing this morning, what is your conflict case between the McMahon decision and what? Because the McMahon and Chavez-Mendez was on the who initiated the discussion. It's on the plea. This is a more substantive issue now that you're talking about. What is the conflict case on that issue?
Your Honor, we're here on certified conflict with Chavez-Mendez.
Does Chavez-Mendez deal with this issue, the substance that we're talking about? As I read Chavez-Mendez, it's a court's initiation of plea negotiations.
And that's the conflict that gets us here. We would hope that the court...
Okay, all right. If I, in my mind, let's just deal with me, if no one else. If I look at that and I say, I don't believe that's a conflict, is there a conflict on this substantive issue that you're discussing with the chief?
No, Your Honor, I cannot point to a conflict with that.
On that.
We supplemented, filed supplemental authority, Clark versus State, which does provide that once this court has certified conflict, if for no other reason than to clear up.
I understand that. I'm just looking to see if there's a conflict case on this substantive issue, and you're telling us no, there is not.
I cannot point to a case that will provide that whenever a trial court refuses to exercise what it must exercise by statute.
Is that, but if that were the basis for the original state appeal, would you agree there isn't an individual basis for the state to appeal the judge's failure to hold a hearing on a request for habitual offender status?
Your Honor, we would agree, but we would hope that this court would recognize that one must look at the entirety of the sentencing proceedings and what occurred in order to determine whether a sentence that results from that proceeding is illegal.
Don't you think, again, the legislature set forth what types of issues can be appealed by the state, and we've said over and over that it's very narrow. It would seem to me that if we know that a definition of a legal sentence would be a situation, for example, where someone has mandatory life, there's no other discretion that the court has, and the judge imposes a 10-year sentence. I guess that would be an illegal sentence for the state to appeal. But I think the category of sentences that the state would want to appeal that are actually less harsh than the state would wish would be very narrow. It would only be where the judge could not, under any version of the facts or law, impose the sentence that the judge is imposing. Are you asking for, and I don't think you'd want to have us change the definition of a legal sentence, otherwise you're going to be opening it up for the defendant who mostly challenges this. So what's your definition, what's the state's definition of a legal sentence?
When there's no plea. There's no plea agreement in this case.
Well, let me ask you this. Why is the definition of illegal sentence that is applied in the context of 3800A necessarily going to be transferred out of that very specialized context over into this context, which is entirely different. There we're looking at unsettling sentences that have run through the ordinary appellate process and unsettling them post-conviction in the post-conviction process, whereas here we're looking at correcting an error that was made that resulted in a particular sentence. Now, isn't there a distinction between these contexts that might mean that those words would be understood differently in this context?
There has to be a difference in the context, Your Honor. And in fact, this court itself has recognized in various contexts sentences may be erroneous. In fact, Rule 9.140CM provides for the state has the right to appeal an unlawful, an illegal, or a sentence that falls outside the guidelines. So this court itself has recognized there will be situations when an illegal sentence is not just a sentence that falls outside the guidelines permitted or recommended by the sentencing guidelines or the criminal punishment code. In this case, in fact, it's interesting, almost 12 years ago to the...
Hang on for a second, before we lose your time here. What is it again that you're considered to be illegal about this sentence?
There is no plea. There was no plea.
So let me ask you this. You heard of the concept of a plea inquiry?
Yes, Your Honor.
Where a defense lawyer walks to a judge with a prosecutor present and says, Judge, my client will take X, Y, Z today. Will you do that? Well, what would you give my client if my client pled guilty to you today? And the judge tells him, the prosecutor objects. Does the mere objection by the prosecutor preclude such things? In your mind, I guess that would make it an illegal sentence. Anytime the prosecutor objects.
Your Honor, it would depend on the circumstances of that case. In this case, all the way through this plea colloquy to the very end, the state continued to say, Your Honor, we're requesting an habitual offender hearing. We have a right to a habitual offender hearing. In this case, this isn't a situation where the interests of justice are served by a trial court attempting to move its docket along clearly. This is a case where the interest of justice is not served because...
No, my concern is your statement that anytime the prosecutor doesn't agree to a plea that is worked out between the judge and the defense with the defense consent, that renders it an illegal sentence. You seem to be saying that.
That was the holding in Gitto. In Warner, this court overruled Gitto to the extent that it was in opposition to this court's holding in Warner. This court's holding in Warner does not say a plea agreement is valid if entered into between the trial court and the defendant without the participation of the state.
It doesn't require the state's participation. So let's set aside hypothetically, no habitual offender in this case. It's just a straight grand theft plea. And the defense says to the judge, Judge, my client wants to plead, wants to resolve it today. We want to plead guilty to this. And the judge go ahead and sentences the guy within the guidelines. State objects. Does that render that sentence illegal?
I don't know that sentence would be, but those aren't the facts we have
No,
here.
what I'm asking you, because you seem to be saying that anytime the prosecutor objects to a plea negotiation between the court and the defendant, that renders the sentence illegal.
In your situation, Your Honor, did the state sign the plea form without objection? Did the state say, you're going to give him this, that's fine, we'll sign?
No,
we'll
let's say
sign this
the state-
contract between us and the defendant?
State completely objects. The judge sentences the defendant within the sentencing guidelines.
If the state is not a party to pleas, then they're not valid pleas.
Okay.
The
Then I
agreement
understand
must
you.
be between the state and the defendant.
I guess if, and maybe this is where I've got to go back and look at the cases, and we'll defer to anybody that has this expertise. If a defendant says, I'm willing to plead guilty, a judge conducts a colloquy, but beforehand, as Justice LaBarge is saying, the judge indicates what sentence they're willing to give this defendant. How does the I'm still having trouble understanding how the state has the ability to say, no, this can't happen, if the defendant's willing, and again, it doesn't involve dropping charges, because, we're only talking about the charges that have been brought, to be able to say, no, you can't, Judge, I object to it. You can't sentence him to 18 months.
It's not you can't sentence him to 18 months. It's we have a right to be heard, we haven't been heard, and we do not agree to what is occurring in its entirety.
If we agree with you, this defendant has now served 18 months and he's out. What is the state seeking in this case? Are they seeking that he'd get a new sentencing hearing, there would be a habitual offender colloquy, a hearing, and then the judge could decide not to habitualize him, and is that an option for the judge?
A different judge, yes, Your Honor.
And then that he could be resentenced before a different judge for 15 years?
When the interests of justice have been served, when all parties have been heard from, when there's a valid contract between the defendant and the state or not, the defendant has the right to withdraw his plea at that point.
Now you say a different judge. What requires a different judge?
It requires a different judge because in this case, Your Honor, the state was in essence asking this judge to please allow the state to be heard. The judge refused. We, as the state, have absolutely every reason to doubt the neutrality and impartiality of this judge.
If we don't order that, you'd have to go in and file a motion to recuse the judge.
That would be fine, Your Honor, and we could do that. We couldn't do it ori tennis in this very quick sentencing hearing that took place.
I understand, but it's not automatic. It goes back to the same judge for whatever happens.
Very well. We would agree to that,
is that correct
certainly.
or not correct?
We would ask this court to hold that it should go back to a different sentencing judge, but if you would prefer to say to the same judge and allow us the opportunity to file the motion to disqualify, we would do so.
You have used all your time. You've used your rebuttal time, but if you want a minute for rebuttal, I will allow you to have it.
I would love that. Thank you very much.
Good morning. May it please the court. Alan Lipson, Assistant Public Defender on behalf of the defendant appellee, John McMahon.
The chief raised, I think, a real significant issue, and would you address that with regard to exclusion of the state in the habitual offender case that we're talking about here? Is that unlike other situations? And I think in reading the transcript, I think the state did have the opportunity to mention what the past was. It wasn't a full hearing by any means, though. So would you address that issue? The question, you were sitting there and heard the question by the chief, why could you not reverse this on the basis that the trial judge here did not let the state be heard in this case? And we're dealing with habitual offender situation.
We have a lot of case law, and they consider this as simply a procedural error in the sentencing process. This is not an illegal sentence, and the state can only appeal an illegal sentence.
Well, but a lot of that case law you cite, I believe, has to do with the term illegal sentence as it is applied in the context of Rule 3800. Isn't that correct?
No, these cases deal with direct appeals by the state. Hewitt, Riley, FG, all deal with direct appeals from the state.
But don't you trace all of that back to the definition of illegal sentence in the context of 3800?
I don't read it that way. It's the Jackson case came out in 2008. You're going back to 1994 with FG. These cases, they simply talk about what is an illegal sentence in terms of 924, 2007.
We know the tortured history about illegal sentences under 3800. And
well, there's been a great history.
There's a great history, but why isn't it the case that whatever that history is with respect to the way we understand illegal sentences within the post-conviction context, that we would not look at this issue of what is an illegal sentence under the rule allowing the state to appeal as a separate question, not necessarily determined by the understanding of that terminology. It is very common in the law that a term in one context will have a specialized meaning that is different than the meaning that is applied in another context. And why isn't it the case that at a certain level we would understand that this sentence, which was imposed by the trial court after it totally ignored the requirements of Florida law with respect to habitualization of and the hearing that was to be held, the findings and all of that, why wouldn't we understand that this sentence is a sentence that was imposed after the trial court had failed to comply with the requirements of Florida law, and in that sense was illegal?
Well, again, this is an error in the sentencing process, and the cases have held that an error in the sentencing process does not render an otherwise legal sentence illegal.
What if it were totally ex parte with the defense? The state's not even there in the room, and the judge enters a plea with the defendant, and it goes. And it's an otherwise legal sentence.
Otherwise legal sentence, I think the state would still have the same problem. This is a legal sentence, and they can only appeal from a legal sentence.
How long has the use of the word illegal by the legislature, how long has that been in 924?
I can't tell you. I can how far that goes back, but I know FG goes back to 1994.
And it was interpreting this particular statute?
Well, FG was a juvenile case disposition, and then all the cases since FG have always cited to FG for that proposition.
And this court, illegal was being used in a very narrow sense.
Right, and in fact, and I cited in Williams versus State, this court defined what an illegal sentence is.
For the 924?
Right, under the entire body of sentencing statutes and laws.
Now you're saying that we were defining that under 924 in Williams?
I believe so, Williams, and then there's also Aikens. Now maybe I'm incorrect about that. But also you did it again in the Aikens case on May 26th.
No, but I think, again, in fairness so that we are very sure about this, when we were in Aikens and in those cases, we were defining it for 3800A.
All right, it's 3.
So what I'm asking you is where was it that the court defined the legislative use of the term illegal? Because what we're really doing is not just making our own policy on this. We're trying to give effect to the legislative intent. I mean, the legislature could say separately that the state can appeal any sentence where the judge does not conduct a habitual offender hearing. I mean, that could be a category of cases that they could.
If they wanted to, they could have said that. There is case law saying that that's a procedural error. This has been around. What my point is, this has been around for a long time. And the legislature certainly could have, in this time, going back to 1994 and forward, could have simply amended the statute and provided for if there's no hearing held on a habitual offender, that renders a sentence illegal.
Now, what I'm sensing, and maybe I'd have to go back and make sure with the way the oral argument went, is that the state wasn't saying that the failure to hold the habitual offender hearing rendered the sentence illegal. What they're saying, we go back to the point, is that if we decide that the failure to allow the state to participate in the plea colloquy negotiation, then we can also address the question of the secondary question on habitualization. Is that how you understood the state's?
Well, I mean, that may be the position, but they never raised this in the trial court.
They never raised what?
They never objected, saying, you've engaged, you've initiated plea negotiations. You can't just enter into a negotiation with the defendant. The only thing they objected to is that we didn't get a hearing on our habitualization. That's the only thing they ever objected to.
So when it went up before the 4th District, did they raise as the reason it was illegal both the failure to the judge's initiation of plea negotiations as well as?
They said the hearing, they didn't get a hearing, and then for the first time on appeal.
As two different bases for it being illegal.
Yeah, on the first time on appeal, they said we didn't get a hearing, and then they added at the very end, they said, and by the way, the judge initiated plea negotiations.
Did the 4th District, did everyone have the same plea colloquy that Justice Labarga read, which is that The judge didn't initiate it?
I didn't understand that at all when they came out with that opinion. Of course, we won the opinion. I didn't understand that. I don't think this. They also said that it wasn't clear from Chavez-Mendez that they were dealing with an illegal sentence. And you read the first line, the Chavez-Mendez says the state is appealing, and then they cite the 9.140, the rule that says the state can appeal a legal sentence, and they tell you he gets probation on a capital sexual battery, and the red flag should go up.
Is in Chavez-Mendez? Is that in a legal sentence the state could appeal?
Yeah, there's a footnote 1. The minute they said the state is appealing that, in footnote 1 of Chavez-Mendez.
So you would agree that one was an illegal sentence?
Yeah, there was an illegal sentence in Chavez-Mendez. I mean, he got probation, and then on the last footnote, they say, and when they remanded it, they say, we note to the trial judge that the only sentence he can give is life with a minimum mandatory of 25 years.
That's a situation where,
Absolutely.
like what I was saying, you have the sentence is life without the possibility of parole, and a judge sentences the person to 10 years. That's that's an illegal sentence for sure.
Correctly. And another thing, let's go back to the habitualization. There's a quid pro quo here. What happened here is they were trying to habitualize the defendant on the theft charge here. And then two things that stood out in my mind. Number one is he was charged as a principal. He did not actually steal the power washer here. So, and just because, the old mere presence and knowledge of the crime doesn't necessarily make you subject to conviction for a principal. But another more important issue is the defense counsel claimed this was an old power washer. It wasn't worth more than $200. Well, that would only be misdemeanor theft, and they wouldn't be able to habitualize him if it was a misdemeanor theft conviction. And the judge said, I will give you 18 months, and I'm not going to habitualize you. That was actually what the judge had offered the defendant, and so the defendant took it in exchange for his right of waiving, going to trial, and trying to contest the cost of this power washer. I didn't know what power washers cost. I went on Sears.com, and they go from $99 to $500 new. So assuming that defense counsel is right, that this is an old one and doesn't worth $200, the state couldn't prove the third-degree grand theft. And when the state said, we want a hearing, the judge said, look, even if we have the hearing, and even if he qualifies, I'm not going to habitualize him.
Can the judge, is that something that, is that the option if he makes the proper findings, that the judge doesn't?
And see, that's the whole thing. Say they do go, and say he does find, okay, you're qualified, but I'm not going to habitualize him. 18 months stands.
But isn't it the case that judges who have the power to make discretionary decisions still have to consider the relevant considerations? They can't just say, well, I've already made up my mind. I don't want to hear what one party has to say, and therefore we're off to the races, and I'm going to impose sentence without following what the statute says. When you admit that what the trial court did here was erroneous, now, I understand you're not going to admit it resulted in an illegal sentence, but you would admit that the trial court erred in what it did?
Case law says that.
Okay.
I mean, case law, they say it's an error. Yes, it is an error. We're not arguing that, but they say it's simply an error in the sentencing process.
And the fact that the trial court ultimately had discretion to give the sentence does not mean that what the trial court did was not erroneous, right?
Right, but it doesn't render the bottom line, the case, but that doesn't render an otherwise legal sentence. 18 months is a legal sentence. Even if he found he was habitualized, if he qualified, the judge could state, I'm not going to habitualize him, which he did in this case, told the state he wasn't going to habitualize this man.
So there's the case law is clear then on the issue that you have to hold a habitual offender hearing.
Right.
So there's no new case law that, we need to establish. The only issue is, can the state separate, if that was the only error here, could the state appeal that under the provision that says it's an illegal sentence?
It doesn't render it illegal. That's what all the case law says. It was error in the procedure.
Are there any decisions other than the Hewitt case that the 4th District relies on, which is one of its own, with regard to that issue, that with regard to the failure to conduct the habitual offender hearing, is or is not an appealable issue?
That's the Riley case. That's what they, on the 3rd D say, and in fact, there isn't some language in a footnote that if a judge doesn't even have to really make the findings of that He's
So the
not going
Riley
to
case,
public
how the third
safety
is-
because if he doesn't give the sentence, gives a more lenient sentence. There's a footnote, and they quote from one of the cases from this court talking about that. If he decides, to give a more lenient sentence and he's not going to habitualize him, then he doesn't really have to make the findings. It's not necessary for the protection.
And of course,
the
the easy fix here would have been years ago for the legislature to have amended the statute and basically say that if you don't afford the state the opportunity to present evidence at an evidentiary hearing before you consider any sentence in this case is an illegal sentence.
Sure.
And what's being asked of us here today, I take it, is for this court to legislate that language in.
Well, that's the province of the legislature, and what I'm saying is this case law has been around for a long time. Not so much out of this court, but it's been out of the DCA's. Riley goes back to the 1990s. A lot of these cases go back to the 1990s, mid-90s, late 90s. Legislature hasn't done anything about it. They don't seem to be dissatisfied with these rulings, and we know when they get dissatisfied with a court's ruling, they immediately act. So it may very well be an error. I'm not arguing, but the courts have held this is an error in the sentencing process, and we believe that this is under this Williams rule definition that it is a legal sentence. It's something the judge could impose. Even if he found the defendant qualified as a habitual offender, he could say, I'm not going to adjudicate him a habitual offender, and he can give him the guideline sentence. I mean, that's the bottom line, that when you look at it, this is a legal sentence, and that's what the courts
if we
have held.
take out that this was a habitual offender case, can you enlighten us on your views as to the state's views that it's a sham sentencing proceeding because the state was not involved in the decision as to what the sentence would be?
I mean, say this was an open plea. No plea, he open pleas, and the court can arrive at the same decision. The court can say, I'm not going to habitualize you. I find 18 months, the bottom of the guidelines is sufficient. The result is the same. I don't see how this is a sham at all. I mean, if it's within the guidelines, it can't be a sham. The legislature has set the guideline. They set the guidelines. This person met the 18-month guideline, and that's what the court gave him. And I said there was a little bit of a quid pro quo in here for not habitualizing because of there was a question as to whether the state could actually get the conviction on the grand theft. And I think it was a little disingenuous on the part of the state. They don't even seem to be objecting to the 18-month sentence in this case. All they're objecting to is to the hearing, but the defendant is pleading to this, and I think in exchange for the fact that he won't get the habitualization. That's the way I read this that went on here, that there is definitely a question mark whether the state could approve that habitualization. And that's why the judge said, okay, I won't habitualize you. I'll give you 18 months if you'd like to take that now. If you want to plea, that's what I'll give you, and the defendant took the plea at that time. Thank you. There's one comment about Chavez-Mendez. That's actually it's not per se reversible error. If you look at the footnote on page 515 of the Warner case, note 515 said that in appeals based upon claims of improper judicial participation in the plea bargaining process, a harmless error analysis will apply, and that's footnote 14 on page 515.
I mean, it is true that in Warner that we were initially and mainly concerned with the coercive effect it might have on the defendant.
Right. Now, obviously, I mean, there's no coercive effect on the defendant here. So, I mean, we still maintain our position. There's no conflict here at all with Chavez-Mendez, and that this ultimately, any way it goes, even if there was a hearing, the court could exercise its discretion. They could absolutely say, the court said, I'm not going to habitualize you, give him a guideline sentence. It's a legal sentence, and the state is precluded from appealing that. Thank you.
Thank you. 1 minute.
Thank you, Your Honor. May it please the court. The fact that we have to stand here today and talk about what the price of a power washer would be as on Sears.com is exactly why everything that occurred below is error. The position and responsibility of a trial court judge is to serve the ends of justice by meting out just punishment after consideration of the circumstances of the crime and the circumstances of the criminal. That did not occur here. In fact, what occurred here...
Let me ask you this. What would you have us do, and how would that affect... This defendant, as I understand it, has been released from custody, correct? He served his sentence.
We would presume 18 months have been served by this point,
okay.
yes.
And so what would be the effect in this particular case, if we accepted your position that the state needed to, was entitled to have an habitual offender hearing, we sent it back for that, and then what would happen?
Your Honor, we would suggest that the defendant would have a right to appear before the court to withdraw his plea, should he determine to do that, and would then be subject to either appropriate plea negotiations where there are two parties and one of them is not the judge. Yes, Your Honor, it does not violate due process because there can be no expectation of finality in a sham sentence, which is what this is.
You know, I really kind of take offense when you call this a sham sentencing. I mean, we really, the trial judge went through the process, and while you may not agree with it, I really don't think that we can truly call this a sham proceeding.
Meaning no offense, Your Honor, there must be a contract between the defendant and the state in order for there to be a valid plea, and that's what we mean when we say there is no contract. The offer and acceptance.
Without a contract with the state, there can't be no valid plea, so therefore you can't make a plea directly to the judge in any instances.
If the state agrees to an open plea with these confines.
If the state, I mean, that's the reason they normally do it, because the state won't agree.
To an open plea within these confines, the state signs the paper, that's a valid plea. Thank you, Your Honor.
We thank you. We thank both of you for your argument. The court will now stand in recess for 10 minutes.
All right. floor is now in session. Please be seated.
We now go to the third case on our docket today, the state of Florida versus Sturdivant.
May it please the court, Assistant Attorney General Charmaine Milsaps representing the state.
Could you speak up a little bit?
Certainly, Your
Thank you.
The state requests that this court revisit its prior decision in Brooks. In Brooks, this court held that the use of aggravated child abuse as the underlying felony for felony murder is limited to situations where there are multiple acts of abuse.
Well, but are you saying, because there's a novel argument that you made, I think it's novel, but there's, for child abuse, there are 3 ways or 4 ways that child abuse can be committed.
3, A, B, and C.
A, B, and C, okay. So it's aggravated batteries A, willfully tortures, maliciously punishes is B, and then abuses a child and doing so causes great bodily harm. This case is actually not even an aggravated battery case. The jury was instructed on willfully tortures, right?
Maliciously punishes.
Willfully, but under B.
Subsection B, yes.
And actually, the jury instruction was under B, not under A.
That's true, yeah.
Okay, so this is not even a Brooks situation. It's not, because it's not an aggravated battery. It's not A.
Well, I don't think Brooks. Remember, the problem with that is Brooks was not charged with the underlying felony, so I don't know which one in Brooks, whether they went under A, B, or C.
But even assuming it's A, B, or C, here they were instructed under B. You are suggesting that we distinguish between an aggravated battery and other types of child abuse. Maybe you can recite or re-recite what your argument is. We'll revisit Brooks, but you would want the court to hold what?
Well, it's in the alternative. First of all, as in Brooks, and I repeated that here, just a plain text analysis. Under plain text, you could use A, B, and C. But in the alternative, if this court is going to use a merger doctrine, it should be a merger doctrine based on the actual legislative history. The merger doctrine is a rule of statutory construction.
Okay, but let's go back to A. I sort of read you as your argument as being that we should redefine it away from single versus multiple acts.
In the alternative, yes,
okay,
Your Honor. You should limit it to be in the alternative.
But the plain language does not even give us that alternative, does it?
No, Your Honor. Under plain text analysis, you would do it, and that was the argument made in Brooks, and I repeated that argument here. Under a plain text analysis, what you do is there's no limit on it because aggravated child abuse is an enumerated felony. Your Honor, when other state courts, Supreme Courts, invoke the merger doctrine, what they're doing is they're doing merger when they don't have enumerated felonies. Aggravated child abuse is an enumerated felony. It's subsection H of this. Not only is this an enumerated felony, Your Honor, but our first-degree felony murder statute was specifically amended. This was a specific amendment to this statute. So not only is this enumerated, it's a specific, particular amendment. Now, and I also provided supplemental authority with a recent case from Idaho saying the merger doctrine is not the law in Idaho, and it was dealing with an aggravated child abuse because the statute of Idaho's felony murder statute was specifically amended to include aggravated child abuse on a child. And then they said the plain language of the statute is not trumped by the judicially created doctrine. By that they mean the merger doctrine that is applied in states without a similar statute. This court is alone in applying a merger doctrine when dealing with an enumerated felony. The Supreme Courts of Arizona, Kansas, Mississippi, and Tennessee have all rejected merger doctrines when they're dealing with an enumerated felony. Courts limit that to when you have a catch-all. California's second-degree murder statute, any felony. Originally in Kansas, theirs had been a catch-all. And the Kansas Supreme Court applied the merger doctrine because it was a catch-all, not enumerated felonies, but said to the Kansas legislature, if you want aggravated child abuse as a felony for felony murder, please amend the statute. The Kansas legislature took them up on that invitation, and then the Kansas Supreme Court, after that amendment, said this is a plain amendment.
So
I'm just saying in the alternative.
you want us to recede from Brooks, and essentially it would be to adopt Justice Lewis's separate opinion.
Yes, but
Justice Lewis got it right.
Yes, that's basically, yes, Your Honor, we do think Justice Lewis got it right. And that was the
Sounds
original.
to me like he did too, as I now look at this, and I'm going to be,
Yes.
my concern had been that it seemed to me that you were arguing for something in the statutory construction that to me would be closer to what it should be, which is an aggravated battery that then becomes, felony murder should be under the merger doctrine. However, I agree with you that the plain language doesn't appear to allow that, and yet, there can be, to me, situations where there can be an unjust situation, but really that's something for the legislature to address, not this court.
Yes, Your Honor.
Now, I
Well,
could say that.
explain to me why you would have a situation where, like Brooks, where you would have two convictions. Explain to me why, what are the elements of each? Usually when you have two convictions, you have an element in one crime that is not in the other one. So explain to me what are the separate elements that would be in the felony murder and the felony.
Okay, now, that's a lot like a double jeopardy analysis. And remember, merger and double jeopardy are two separate things.
Tell me what are the separate elements. That's what I'm asking you.
This court has a whole series of cases saying that double jeopardy is not violated when Edmund, going back 30, 40 years, that when you have an underlying felony and a conviction for felony murder, that does not violate double jeopardy. None of the enumerated felonies for felony murder, traffic, arsoning, sexual battery, robbery, et cetera, none of those. You may have dual convictions for both of those.
The answer to the question is there is none. Is that the answer? The specific question I asked you about a separate element. There is no separate element. Is that what you're saying?
Your Honor, first of all, yes, there would be. The felony murder, first of all, would require the death of a child.
Okay.
And aggravated child abuse requires, you're going to, if you look at the definition, none of them talks about death. Okay? So there's going to be different elements. But, Your Honor.
So that's if you would just answer the question, whether you believe or not, I would like you to just answer the question. You have, in those two crimes, what is the separate element? The death would be the separate element in the murder, in the actual death of the child, correct?
Yes, the actual death of the child and aggravated child abuse does not, under its definition, necessarily require the death of a child. If you look at A, B, and C, death is not required for that. So one of the differences would be death. But, Your Honor, I mean, what you're really asking me is does double jeopardy preclude a conviction for the underlying felony and felony murder? And the answer is no, and the answer's always been no.
I think my concern in Brooks had been the issue that's really more addressed to the proportionality, that somebody who commits an aggravated battery then ends up where the child dies. You've got, the child's under 12, there's the felony, underlying felony, and there's no separate act. I think that probably the way to address those cases is really to see whether that would still render if there's nothing else aggravating, whether that would render it a disproportionate sentence, which is really not what we're dealing with here.
No, Your Honor, this is not a capital case.
Would you agree? I mean, there could be that problem in a death penalty case that wouldn't be here in a case where the death penalty is not being sought.
Yes, Your Honor. I mean, you know, depending on the facts, you all do you call it doubling, but your doubling analysis in the death penalty aggravators context is a lot like a double jeopardy, and you require different sets of facts underlying the aggravator from the crime. And depending on, in the future, Your Honor, it would be hard for me to answer that in the abstract, but under your doubling analysis, you would probably have to have another aggravator,
now,
prior violent or
Brooks
something.
came out in what year?
2005, Your Honor.
And it's now 2011. Is there anything to the argument that for 6 years the legislature saw how this court had then narrowed the felony, the child abuse underlying felony, and didn't re-amend the statute? Or does that not apply because it's a plain language analysis?
Well, Your Honor, that's something that courts often look at. We interpreted it a way, the legislature did. But understand something, Your Honor, I don't think that applies here, and here's why. No conviction until now has been reversed on Brooks grounds. Brooks itself, the conviction was not reversed. I don't think the legislature reaches out to correct errors when no convictions are getting reversed. Until this case, no conviction has been reversed. In the wake of Brooks, the 5th DCA in a case called Dorsey held that shaken baby syndrome, that was one of the big concerns in the wake of Brooks. I had a lot of calls about Brooks, and that was the big concern, whether shaken baby would be prohibited under the Brooks decision. I thought no. They went ahead and prosecuted shaken babies. And the Dorsey, the 5th DCA, said that was fine. Your Honor, the first time a DCA reverses a shaken baby conviction, I think the legislature will act. I think this is a unique situation. Brooks itself was not reversed. No conviction has been reversed until now, based on the single act, multiple act dichotomy. The legislature's not going to reach out until convictions get reversed. They're not going to do that. So why I realize that's something that courts normally look at, whether the legislature reacts, that's just a general principle. You need to look at it in the actual context. Until convictions are reversed, they are not going to say.
Well, plus, it's really something that we only do if the language isn't plain. And I think here it's plain.
Yes, Your Honor. I mean, aggravated child abuse is an enumerated felony. My argument in the alternative about limiting it to C was just, if you're going to do the merger doctrine, it should be a merger doctrine based on the actual legislative history of this amendment. But the state's real position, both in Brooks and here, is a plain text analysis, and that courts, and it's clean sweep, Your Honor. When people are up here and they talk about the Supreme Court of Arizona, Kansas, Mississippi, and Tennessee, I always think to myself, okay, what about the other 45? Well, there are other 45. It is a clean sweep, Your Honor, of the Supreme Courts that ever addressed it dealing with an enumerated felony. They do not apply the merger doctrine. They follow the plain text of the statute. And so that's what the state would.
Let me ask this question, speaking historically for a second. You know, in Mills, we held back in '85 that it was not proper to convict someone of the underlying felony and then felony murder. Of course, the underlying felony in Mills was aggravated battery, which was not an enumerated crime at the time. And I think your position is that Brooks improperly relied on Mills because of that factor. But in this instance here, aggravated child abuse is an enumerated crime under the statute. What for purposes of double jeopardy or even merger, why is it that it's enumerated make it a difference? What factor does that play?
Well, now, Your Honor, there are really two different merger doctrines. old common law murder was a precursor, a judicially created precursor to double jeopardy. And that's not the kind of merger that we have in Florida. What we have in Florida of the merger doctrine is it's a rule of statutory construction. You're really just looking at it for the purposes of that. So the difference there, I think, is when you're dealing with an unenumerated felony, one of the things that the states that do follow merger with unenumerated felonies, their logic is the following. If it's unenumerated, then something like aggravated battery could serve as the underlying felony, and all murders would, because the vast majority of murders involve an aggravated battery, all murders would automatically become first degree. And that would negate both second degree and manslaughter. It would take them off the table. So those courts, as a matter of statutory interpretation, said the legislature couldn't have meant aggravated battery to be one of the enumerated felonies because it would have the consequence of taking both second degree, all the lesser forms of murder, second degree manslaughter, third degree felony murder off the table. And we don't believe that the legislature meant to do that. So they invoke the merger doctrine really as a rule of statutory construction, okay? I do not think the merger is not proper in the old double jeopardy sense. That was old common law, really old common law. We have now, prior to Blockberger, and we have a statute codifying when dual convictions are proper and when they are not. Okay, so we're not dealing with the old judicially created kind of merger. My merger argument is more as a rule of statutory construction, because that's the only kind of merger that really exists in the wake of Blockberger. The old common law merger does not. Merger is not correctly understood, is not a form of double jeopardy. It should not be. It's just a rule of statutory construction, understandably employed when you think that the consequence of letting aggravated battery serve as an enumerated felony is going to be to negate all other types of murders. What they said to themselves is, we don't believe the legislature intended that.
You have used all your time but 3 minutes and 13 seconds.
Okay, I will save my 3 minutes and 13 seconds for rebuttal. Thank you, Your Honor.
May it please the court, my name is Paula Saunders. I represent the respondent, Robert Sturdivant. Let me first address Justice Periante's comments. When the legislature included aggravated child abuse as an enumerated felony for felony murder in 1984, there were 3 alternative methods in which child abuse could be committed. There was an aggravated battery, malicious punishment, and torture. The case that gave rise to the statutory amendment involved a case of systematic abuse of a child. There was repeated beatings and withholding of food and water. The 5-year-old child succumbs and the body was hidden, and by the time the body was discovered, it was decomposed and the cause of death could not be determined.
But I understand this history, and actually the state has detailed a lot of this history in the state's brief. But what has that to do with anything unless the statute is ambiguous?
Okay, the statute's not ambiguous.
Okay, well that seems to me to be an important concession on your part.
I agree, but I also think that there's a significance to the word any. When the cause of death could not be determined, you could have had an aggravated child abuse based on aggravated battery, based on malicious punishment, or based on willful torture, and the legislature said that any of those 3 alternatives will support a conviction for felony murder. But an aggravated battery can be multiple beatings with multiple injuries. Malicious punishment and torture can be withholding of food and water, which don't involve a battery at all. There was nothing in the legislative intent, however, that addresses whether that single slap, one battery with only one injury, should constitute felony murder.
Well, I'm sorry, I don't understand that argument. because if you're speculating about legislative intent when we have the words that are unambiguous. And if you've conceded that the words in the statute are unambiguous, why doesn't that just settle it?
Because any refers to any of the alternative methods of aggravated battery, but it doesn't express an intent to undo the merger with regard to that single slap where there's a single injury. And in fact, Justice Lewis in Brooks invited the legislature to re-examine and reevaluate the statute if the Brooks opinion did not follow the legislative intent. And in the last 6 years, the legislature has not revisited or re-examined or clarified its intent. And we certainly know that the legislature doesn't hesitate to enact new laws when it disagrees with opinions of this court. I mean, you look at Carawan, Chacon, Delgado, just to name a few. But the legislature cannot silently abrogate the common law merger doctrine, and it has never expressly abrogated the merger doctrine.
Is Ms. Milsaps correct that the common law merger doctrine was a double jeopardy doctrine? The common law merger doctrine.
Correct. Okay. And we're not dealing with double jeopardy here.
Right,
I agree.
So now we get back. So do you agree that the merger doctrine then becomes a statutory construction principle?
Yes.
Now, if though, and this is my problem with what I wrote 6 years ago, is that if the statutory language is clear, and the way that the legislature could have made it clear is either not included A, because A commits aggravated battery was there at the time the statute was amended, and it's there now, or said something about it had to be one or more acts, which to me is, I can understand, or to me there's a difference between slapping a child who then dies by hitting their head on the table versus what we think of as child abuse, the kind of child abuse that is
systemic abuse.
Right, but it does exactly, and I agree that that's a difference, but it doesn't appear that the legislature made that difference. And then in this case, and whether I realize we talked about single versus multiple acts, but the one I was concerned about was aggravated battery, and this one was a malicious punishment. So the the jury had to find something separate, that it wasn't just a slap that just ended up by chance and ending in death, but there was a malicious punishment, and that it was or willfully tortured. So child abuse means an intentional act that could reasonably be expected to result in physical injury or mental injury, and it went on, the jury instruction in this case. So my concerns that I had in Brooks really are less of a concern here, assuming my concerns should mean anything, which if it's plain language, it's really irrelevant that I have these concerns.
Okay. First of all, he was charged in the alternative with malicious punishment or willful torture or by intentionally causing great bodily harm. I don't think it matters what label.
Let me just say, the jury instruction said, only stated, unless I
can clarify that.
316 to 317 of the transcript.
Right. And when the motion for judgment of acquittal was made in the trial court, the judge said, I agree that the aggravated battery subsection A and subsection C, the causing great bodily harm, would merge. And I'm only allowing this to go to the jury under malicious punishment or willful torture. But I don't think it matters what label you put on it.
It matters to me in that, in terms of this case, there was a way, that we're going to be deciding a broad issue, but narrowly, it was only under B that that the jury was instructed and that he was found guilty.
It was still battery. So whether you call that battery aggravated battery or malicious punishment or causing great bodily harm, it's a battery.
But the
and the
jury
merger doctrine
certainly,
looks at the act, not the label that we put on it.
No, because I think in arguing to a jury, if a slap that just ended up causing a death by them, having fallen off of a tape, again, I'm just giving that hypothetical, the argument can be made by the defense lawyer, but this isn't what we mean by child abuse if we're looking at willfully tortures or maliciously punishes. That seems like a higher burden than an aggravated battery. For the jury...
It's not a higher burden.
Well,
it's all the same act. They charged it as being a single slap.
What happened here? What were the facts that the jury heard in this case?
All right. Mr. Sturdivant made a statement and, in fact, gave a videotaped reenactment of the crime. He comes out of the bathroom. He finds the child standing on a coffee table. He's told the child in the past not to climb on the coffee table. He hits the child one time on the back of the head, and there is, in fact, a pattern injury on the back of the head with the fingers of the hand on the pattern.
Not exactly a
so
slap
that's
on the wrist.
one slap. It wasn't a punch. It was a slap with finger pattern. The child fell off the table, hits its head on a concrete wall, and the child then succumbs to a head injury. But there's no question that it is a single slap, and in fact, when the state moved to consolidate the information and the indictment for purposes of trial, they filed an information on second-degree murder because they were worried about the Brooks merger issue. So as a fallback position, they filed the information on second-degree murder. And in the hearing on the motion to consolidate, the prosecutor acknowledged this case involves a single slap. There are no other injuries. There are no other allegations of abuse in this case. It is one slap case.
But I thought you said in this case that not only was there a single slap, but that the single slap resulted in the child hitting his head on a concrete wall.
It's cause and effect. I mean, there was one slap, and the child fell and hit his head.
Well, in my mind, it makes a difference. If the child had died from the single slap, as opposed to the child having died from hitting his head on the concrete wall, you don't think those are two different issues? Or two different matters?
No, because the actual act that caused the child's death was a slap, one slap.
So the
if the victim in this case had been an adult and had been punched in the head, had fallen over backwards and hit his head on the ground and dies as a result, that traditionally has been treated as either manslaughter or second-degree murder, and the Mills merger doctrine would apply.
But this is not an adult. But this is not an adult.
The only difference here is that we're dealing with a child.
Protects the disabled, the elderly, and children, specifically under the statute, doesn't it?
Yes, it does. But also...
It's because of the status of the individual.
When aggravated child abuse was incorporated into the felony murder statute, it was a second-degree felony punishable by a maximum term of 15 years. Today, aggravated child abuse is a first-degree felony punished by 30 years. So there clearly is a legislative intent there to punish people who abuse children more severely. And it doesn't matter whether it's a caregiver or whether it's a stranger. The abuse of the child is punished very severely. The question is whether we want to elevate that child abuse to a capital felony when it is the result of a single act with a single injury.
Well, that's a good policy argument to make to the legislature. The problem is that we're not the legislature, and they enumerated this felony, aggravated child abuse, and that's, as far as I'm concerned at this point, unless you can show me any other reason other than that we don't think the legislature, did he get a life sentence?
Yes, mandatory life sentence without
That the
parole.
legislature didn't intend for this to end up with a mandatory life sentence. I don't see how we get around the language used by the legislature since 1984.
The merger doctrine is a long-standing doctrine.
Of what? But let's go back. It's a doctrine of statutory construction.
Correct.
Which means that there is some ambiguity. We obviously decided in Mills that the ambiguity was that because it wasn't an enumerated felony, that it couldn't be that the legislature intended that every aggravated battery was going to be prosecuted as a first-degree murder case. We made that judgment. The legislature hasn't changed to put aggravated battery as a enumerated felony.
Correct. And I think that's a recognition by the legislature that that single battery should not be elevated to a felony murder by virtue of the merger doctrine.
I mean, it seems to me, if anything, for what's happened with aggravated child abuse over the last 30 years, just as you said, a recognition of raising it to 30 years, that if anything, this is consistent with the legislative intent that to punish as severely as we can anybody that would abuse a child. How old was this child? 2-year-old child. To slap that child so hard that there were finger marks left on the back of the child's head. Doesn't sound like a little slap to me to begin with, but that's where I'm sympathetic. Obviously, I wrote what I wrote in Brooks, but in looking at this in this context, I just don't see how you get around the plain language.
I think there's a clear recognition by the legislature that an aggravated battery would merge with the homicide, and for that reason, aggravated battery has never been included in the felony murder statute. I think the legislature, at least implicitly, has applied that in the context of the aggravated child abuse, because we know we can have aggravated child abuse by an aggravated battery where there are multiple beatings and multiple injuries. And the legislature has never expressly stated that the merger doctrine should not apply where there is a single battery without any additional injury.
In this case, the defendant struck the child, right?
Yes.
The child fell off of the table that the child was on and hit his head on a wall.
Correct.
And the medical examiner said the child died from what?
From a hematoma that formed in the brain.
From the
head injury.
From the slap, or was it from hitting the head?
That either one could have been the cause of death, either the hitting of the head by the hand or the hitting on the wall. And I don't know that it was clear, and in fact, the medical examiner who performed the autopsy, Dr. Siebert, was not the medical examiner who testified at the trial. But it was a head injury that either resulted from the slap or from the hitting of the head.
So you don't see this case as a different situation from just a single act. It seems to me that no matter how you look at it,
the defendant did one act.
The defendant did one act, but two things happened.
Well, there's a cause and effect, which there typically is when you have a battery or a homicide.
Obviously, there were two injuries here also. The slap from the defendant and the hitting of the head on whatever wall or a wall. Is that what you said? Okay. And so, I'm really looking at this now as a different case from just the defendant hit the child and the child so hard that the child died. This child not only was hit hard, if you've got these prints left on it, but the child also hit its head on the wall.
Well,
that's correct.
The medical examiner did testify that the blow to the head of the 2-year-old was sufficient to cause his death. Correct?
Yes.
Well, you keep talking about it being a one slap. It was one slap enough to cause his death.
That's correct. But that was the premise of Mills and Brooks, is that it is a single assaultive act that does not cause additional injury, and that's what we've got here. If it were an adult, clearly Mills would apply, and the battery would merge into the homicide. And the only difference here is that it's a child, but it's still a single act.
It's, as Justice Lewis said, it's a big difference. It's a 2-year-old child, and it is not an adult that was being, where they were in the middle of some fight, and each person slapped the other person, and then the one person fell and then died.
Well, I think that the state agrees that the legislature did not intend to abrogate the merger doctrine when it incorporated aggravated child abuse into the felony murder statute.
I don't think they agreed to that at all. I don't think they agreed to that at all. They've argued that every state that looks at the enumerated, they treat that differently. The argument may be totally different if you didn't have the enumerated statement.
The state has asked this court to simply redefine the merger doctrine and consider the caregiver versus the stranger situation, and has not argued that there's no longer merger. And if merger is a rule of statutory construction, then we have to look at our legislative history, and it doesn't matter what any other state has done. But in the last minute I have remaining, I would like to address the remedy in this case. Brooks was indeed the law at the time that this offense occurred. Mr. Sturdivant should have the benefit of the Brooks decision. Had the trial court followed Brooks, then a motion for judgment of acquittal as to the felony murder should have been granted. What's noteworthy about this case is that the theory of defense was voluntary manslaughter, and the defense counsel objected to the trial court giving an instruction on manslaughter by culpable negligence. The First District has remanded this case for entry of a conviction for second-degree murder. And it is our contention that that second-degree murder conviction can't stand because of the flawed Montgomery instruction on voluntary manslaughter. The Montgomery instruction is fundamental error, and the case would have to be remanded for a retrial on second-degree murder with a proper instruction given on manslaughter by act. And since that was the theory of defense in the case, and manslaughter is one step removed from second-degree murder, this case should be remanded for a new trial. Thank you.
I'd just like to get a couple of things straight.
Can you respond to that last argument about the remedy in this case? Is there a flawed Montgomery instruction that was given?
Yes, but there was also an alternative kind of the remedy here, if you do reverse this, would be just to enter judgment, exactly what the first DCA did for second-degree murder, okay? There was intent to kill given, but there was also manslaughter by culpable negligence. All 5 DCAs have held that when there is an alternative, the problem in Montgomery was only the one kind, manslaughter by act was given. Manslaughter by culpable negligence was not given in Montgomery, but it was here. All 5 DCAs have held that is not fundamental error. Going back real quickly, when the prosecutor testified in front of the legislature, he gave not on the crime that gave rise to this, but he gave as part of his testimony an example of a single act where a boyfriend punched a crying toddler once in the stomach and the child hemorrhaged to death 8 hours later from a lacerated liver. So the legislative history clearly shows that the one act, multiple acts did not matter to the legislature. They were given that as an example. Moreover, Your Honor, I think there's a little confusion about what the aggravated child abuse statute said at the time. And I put that on page 45 of my brief. There were, in fact, 4 ways to prove aggravated child abuse at the time this statute was amended. The 1st, the statute said that the aggravated child abuse statute was amended. The 2nd, the statute said that the aggravated child abuse statute was amended. The 3rd, the statute said that the aggravated child abuse statute was amended. The 4th, the statute said that the aggravated child abuse statute was amended. The 5th, the statute said that the aggravated child abuse statute was amended. The 6th, the statute said that the aggravated child abuse statute was amended. The 7th, the statute said that the aggravated child abuse statute was amended. The 8th, the statute said that the aggravated child abuse statute was amended. The 9th, the statute said that the aggravated child abuse statute was amended. The 10th, the statute said that the aggravated child abuse statute was amended. The 11th, the statute said that the aggravated child abuse statute was amended. The 12th, the statute said that the aggravated child abuse statute was amended. The 13th, the statute You could do it by aggravated battery on a child, and then willful torture. 3 was maliciously punished, and 4 was willfully cage. All right, so I don't think that the statute at the time was that. And I would like to get straight, the argument was only in the alternative. No, I do not agree. The merger doctrine does not apply when you're dealing with enumerated felonies. No state Supreme Court has said that. Every state Supreme Court, it's not a double jeopardy construct. It's a rule of statutory construction. And you don't even need to get to it under the plain text, but if you're going to get to looking at the legislative history, it's very clear the one act, multiple acts did not matter to the legislature.
Again, in fairness to Ms. Saunders, you read your summary of the argument on page 5, it does appear that you were saying that we should not limit, we should limit the types of child abuse that would be underlying felonies. But anyway, you're not bound by whatever you said anyway.
No, but look at footnote 4, and look at the original. I was the attorney in Brooks. I made a straight plain text argument. So no, and I also reiterated that in not only the initial brief in this case, but in the reply brief as well. And I provided supplemental authority. I didn't want to confuse. I do want to get it straight that the state's original position was and remains plain text. But in the alternative, merger should be a proper kind of merger. If we're going to do merger, it should be the right kind. I also wanted to just very quickly, the first DCA was a little confused about the Brooks opinion. So I would like to explain that I think what you did was that was a holding, but you in the alternative found the error to be harmless. The United States Supreme Court in a recent case, Hedgepeth versus Puleo, has receded from Yates. Yes, you may do that. You were free to do it at the time, and you did do it. I would also, Your Honor, just to get a fact real, when you say slap, it makes it sound like, and I realize they used it in the charging document, but understand how hard this child was hit. This child flew off the coffee table. Feet. This child did not fall to the wall. It flew off this coffee table into a concrete wall. This child was hit so hard that the treating physician couldn't even, thought maybe the blow itself would have been fatal. This child was hit that hard. So let's not get the wrong impression from the word slap. This child was severely hit, and hit so hard, flew feet into a wall. Thank you, Your Honor.
We thank both of you for your argument. We now move to the fourth and final case on today's docket. Petty versus the Florida Insurance Guarantee Association.
May it please the court, Brian Gowdy of Creed and Gowdy on behalf of the petitioners. With me at counsel's table is my co-counsel, Ron Hobgood. Today, this court must decide whether the following type of claim is a covered claim that FIGA must pay. An insured's claim for section 627.428 fees incurred by an insured in a suit against its now insolvent insurer that before the insolvency confessed judgment on the underlying loss claim. A covered claim is one that must arise out of and be within the coverage of the insurance policy. That's what section 631.54 sub 3 states. The type of fee claim that we are here today on is a covered claim because section 627.428 is a part of every insurance policy in Florida, and it obligates every insurer to cover the fees incurred by its insured in successfully prosecuting a suit against the insurer.
Mr. Gotti,
Yes.
why doesn't Section 631.70 control the outcome of this case?
Section 631.70 provides a separate analysis for post-insolvency fees distinct from the analysis under Section 631.54, which deals with covered claims.
Where
and
does
there's
it,
three.
where does
and
it
there's
say
three.
post-insolvency?
Well, I'm going to point you to the plain language. I'm going to point you, and then I'm going to point you to some history. First, you're right. It doesn't say post-insolvency, but what 631.70 says is that 627.428 shall not be applicable to any claim presented to FIGA. Let's stop there. They conceded in the trial court, FIGA conceded in the trial court that the underlying loss claims were never presented to it. Page 19 and 20 of the summary judgment transcript, hearing transcript. The underlying loss claim was never presented to FIGA. The only claim that has been presented to FIGA is the fee claim under 627.428. And that was the facts in Soto as well from the 3rd DCA. The fee claim, the underlying loss claim, both here and in Soto, were fully paid before the insolvency. So the only claim that's ever been presented to FIGA is the 627.428 fee. So let's continue on with the plain language. Except when FIGA denies by affirmative action a covered claim. And here we're contending that the fee claim is a covered claim under 631.543, and then FIGA's clearly denied it, as we're here before the Supreme Court now arguing over whether it's a covered claim, as well as by other proceedings below. So, 631 does not, I'm sorry.
I'm sorry. I'll let you
631.70 doesn't apply under the plain language, and I'm happy to go in some history, but...
Well, this all turns on whether this claim for attorney's fees is a covered claim.
I agree.
I mean, that's not really oversimplifying it. There are different angles to approach it from, and you've got these various statutes that interact, and I think you've done a very nice job in your brief of making your case. But let me ask you this. Don't you have a problem with the concept of covered claim in this context? Because that points us to a meaning that's not related to attorney's fees, but related to a claim that is against an insurable loss, something that's covered in the sense that insurance provides coverage for losses. And that kind of ordinary understanding of the term of coverage and covered claim is really at cross purposes with your argument.
I agree it's at cross purposes with the ordinary and probably typical thing when you think of coverage. But let's go back to 631.54 sub 3. The only example that it gives of a covered claim is an unearned premium. And
well, is that really an example? I mean, I think that's a good argument. But that is so different than covered claim. And when I read that, I almost think they're talking about covered claims and they say, and we're going to add this, even though it's not really something that you would think of as a covered claim, but it's kind of a tack on.
But that's not what the language says. It doesn't say and. It says a covered claim means an unpaid claim, comma, including one for unearned premium, comma, which arises out of and is within the coverage of the policy. And so therefore, the which clause modifies both covered claim and modifies the general term unpaid claim and the specific example unearned premium. And just to show you how it is analogous to attorney's fees, both cover a risk that's controlled, a risk of an occurrence controlled by the insurer. For an unearned premium, it typically is going to happen when the insurer decides to cancel the policy. And let's say an insurer 30 days before insolvency, 15 days before insolvency, cancels the policy and fails to return the premium. I have a claim for an unpaid, for the unearned premium. I can get it from FIGA. Did FIGA do anything wrong? No. but clearly under the statute, I'm allowed.
But again, I guess, and it really is, to me, and I'm sort of going along with what Justice Kennedy said, unearned premiums don't arise out of and is within the coverage in a typical sense. So my thought is that they were including this unearned premiums because that would not be otherwise a definition of a covered claim that arises out of the coverage. The alternative argument is to say they could have just as easily said, including one of unearned premiums and previously incurred attorney's fees under 627.428.
Well, I mean, they could have listed all the examples, and if you...
What other example? But let's go over it. What else other than... what would you agree could not be under covered claim? What would be, give me another example.
I would tell you a negligence or a fraud claim where you're trying to get a return of a premium would not be a covered claim. But if the statute says that an insurance company, when it cancels the policy, must return the premium, that would be a covered claim.
Well, but
so unearned premiums can be, unearned premiums and fees can be on both sides. You have to do the analysis and ask whether it's within the coverage and arises out of the policy.
But part of your argument is that this is covered because it's implied by law to be part of rights that are that the policyholder has.
Correct.
Well, wouldn't that apply to the claim for negligence that you were?
No, that would be a general tort claim. It's not based on.
But it's something that the policyholder has. Still be part of what the law provides as a right.
Well, the case law that we cite does not say that general tort claims like fraud or generally applicable protection statutes that are outside of the insurance context are incorporated into the insurance policy.
You would have 624-155 would also go in. That's a statute.
Well, I think that would be a much closer question, because if you go back and you trace the history of bad faith, and you even mentioned this in the court mentions this in the Jones opinion, those have often been considered non-contractual damages. And I think that
But the statute, your argument is that it's part of every contract, and 624-155 is part of every contract now.
I don't think this court has ever, I'm unaware of any decision that this court or even a DCA has held that 624.155 is a part of every contract. Now, 627.428 is under Chapter 627, which is titled the insurance contract.
Well, I can see your argument if you had defended the insured, and the contract, we know liability policies cover both defense and payment.
Right.
They provide, and if that had been done, those attorney's fees can be, I think, legitimately argued. Would you not agree, as part of a covered claim under the policy?
Correct, I would agree. Now, the second would not, under its all-the-way decision, I think.
But again, you're in a different category. You're in a different category. You're under first-party benefits under the contract.
Correct, and it's a statute that's under 627, which is titled the insurance contract, that this court has repeatedly held is a part of every insurance contract in Florida, has repeatedly held for 75 years, and therefore, because it is part of the insurance contract, it covers a risk that is triggered when the insurer refuses to pay. And so therefore it arises out of and is within the coverage of the policy. I think I understand your questions about 624.155. I have looked at that some. I think that's a whole nother case. I don't think necessarily it follows that just because you ruled today that 627.428 would give rise to a covered claim that's a bad faith claim under 624.155.
I would agree with your argument to a certain extent that attorney's fees under the example that I suggested to you is in the nature of a covered claim, because the policy promises to defend you and promises to pay the claim. Liability situation. Not the same with the first party benefit like we're involved with here.
But if the let's say the policy expressly cut and paste 627.428, out of the statute and put it in the policy. That we're now putting form over substance. I mean, every policy by Florida law includes that provision, whether or not it's expressly in the policy. And there's lots of other examples where even if the insurance policy does not expressly say something, for example, it has the incorrect amount of coverage that's required by law, that's going to be incorporated into the policy because of the heavily regulated nature of insurance contracts. So I think the lack of the express provision, you're agreeing with me, Justice Lewis, that the liability provision, it would be covered. Well, wouldn't it be just silly to say, well, if the insurer had written 627.428 into the policy, it would be covered then?
I can see interpreting the statute to that extent where there's a duty to defend. But I do. I mean, it's interesting, the limits. I mean, there are others that, I hear what you're saying.
Yes,
Your argument that attorney's fees are implied in every contract, that derives from State Farm versus Palma. Is that correct?
Well, actually, it goes back 75 years.
But in Palma...
Palma's, I think, the most famous case, but it's actually in a lot of cases.
Some kind of radiology of something that the attorney wanted, he had to seek payment for and sought attorney's fees for that?
I think the precise issue in Palma was whether or not you could get fees for time spent litigating fees. And the court concluded you could for entitlement to fees, and the only way the court could reach that conclusion was to hold that 627.428 was part of the policy, because if you go to 627.428 itself, it makes it clear you can only get fees for things that are under a policy, with the exact words, under a policy. So for you to hold here differently would be inconsistent with Palma, because if it's not part of the policy, then Palma's wrong, because you can't get fees for anything that you've spent litigating that's outside of the policy. So you're not going to be able to reconcile their two decisions if you disagree with us. The other reasons, just real briefly, I wanted to get back to Justice Polston's question, which is if you go back and look at the Zinc-Smith case, which FIGA has conceded was the genesis for the 1977 amendment to 631.70, that was only involved post-insolvency fees.
Let's talk about the plain language again for a moment.
Okay.
Your whole argument is that the attorney's fees under 627.428 are part of the covered claim in this case.
It's part of the insurance policy, and therefore it is a covered claim. We have two covered claims in this case.
All right, well, if it's part of the claim, you're still talking about that it's included in the claim to FIGA. So what you're really arguing, it seems, is that attorney's fees under 627.428 is part of the claim now being presented to FIGA, which 631.70 clearly prohibits.
I guess I have to correct your premise, which is you keep saying a claim presented to FIGA. You can imagine an insurance policy, you have multiple coverages, one for one for liability, and you could have multiple claims under the same policy. The law has always recognized that. You can have multiple claims out of a judgment.
One of which you're trying to make one for attorney's fees.
Right, but you keep saying that it's part of the claim. It's part of the fee. It's part of the fee claim. Yes, I mean the fee claim was presented to FIGA. The loss claim was not. So the fee claim was presented to FIGA and denied, and therefore the 631.70 doesn't protect FIGA.
Does the procedural setting in this case make a difference with regard to, in your case, you already have the judgment was already entered, correct?
That's critical. I think if there was a confession of judgment, which under this court's case law is
tantamount to a judgment.
If there had not been a judgment, we would probably be, I would concede, we would not be able to get our fees in this case.
Well, did you say, was there any different, and I was going to sort of follow up, does it matter, there was a motion for an award of attorney's fees, but there was not a judgment entered for attorney's fees or a determination of amount?
There was not, but under this court's, Wallard and other cases, this court has held that once the insurer pays, that's a tantamount to a judgment.
But the amount was not determined.
Well, the amount of the loss claim was.
The amount of attorney's fees.
No, but.
So now, let's go one step further. now you say you're entitled, say, to $50,000. It's presented to FIGA, and they say, well, we'll give you attorney's fees, but we think, looking at this, you're only entitled to $10,000. That's litigated. Do you get fees in determining how much is the amount of the fee?
No, not under PALMA. You only get...
No, also not only under the language, you can't get it against FIGA.
If FIGA admits that they have to pay the fees, like
something.
If when it was presented and they said, yep, we have to pay, and then we just spend time litigating the amount of fees, I would agree under both the statute and PALMA, we're not entitled to fees for time spent litigating the amount of fees. I'm into my rebuttal time. I'm happy to answer questions or reserve the balance.
Pleases the court. Bill Bissett, representing the Florida Insurance Guarantee Association. Did have some points to cover, but I'd like to try to discuss some of the questions that have been asked. And how
has FIGA always taken the position that any attorney's fees, even if, say, in this case, the judgment had already been entered for the amount of attorney's fees, is not within the coverage of the FIGA statute? Does it matter at what phase of the proceeding the attorney's fee claim is?
Does it make a difference?
It does or does not?
631.70 is right on point.
So you would not rely on, that's what I see. I'm relying on the covered claim portion, but you actually are saying that we could first decide it just under 0.70, being that is a separate reason for upholding the second district's decision?
Correct, Your Honor.
How will you distinguish Palma? How will you distinguish Palma from this case?
Palma, actually, the only portion of that decision that's relevant is about one sentence, which states that 627.428 is an implicit part that's read into a policy. In effect, what the court was saying, that under that statute, when a dispute arises between an insured and insurance company over either a delay in resolving the case or resolving the claim, or in outright refusing coverage, and a lawsuit has to be filed to attempt to obtain the benefits, the coverage under the policy, then that statute declares that the insured will be able to recover reasonable attorney's fees. It's part of the policy that the Florida legislature, it's a statutory obligation that's been determined repeatedly to be in the nature of, or to actually be a penalty, which is a separate argument.
Why isn't a reasonable reading of 631.70 really is that you cannot get attorney's fees for your dealings with FIGA unless unless they're doing something that's delaying it and unreasonably, or because I don't read that. Quite frankly, I don't read that as saying that FIGA is not going to have to pay attorney's fees that have already been determined, that just they were not liable for attorney's fees in your interaction with FIGA unless FIGA is having some unreasonable delay.
Well, I think the key word in that sentence is the provisions of 627.428, which their entire claim is predicated upon, provides that attorney's fees shall not be applicable to any claim. Any claim. It doesn't say pre-insolvency versus post-insolvency, and the word any has broad, all-inclusive meaning, and you would have to ignore that word.
Any claim that is brought to FIGA, as opposed to any claim that has already been litigated. I mean, it seems to me that is just a reasonable reading of that as your reading of it.
What would make it, from a policy standpoint, unreasonable is that if it only applied to post-insolvency, things that FIGA can control, but leaves open this wide door for the assessment of attorney's fees based upon the failure of the insolvent insurer to properly handle the claim and to pass that enormous amount of attorney's fees, typically way beyond what the value of the claim was.
So when
But
can-
you do agree that there's two aspects to liability policies, correct? You've been doing this for a lot of years, right?
A lot of years, yes, Your Honor.
Okay, so there's two different things, duty to defend
The duty to defend.
and duty to pay the claim.
Correct.
If they don't defend in the liability context, you're saying that the FIGA statute has no responsibility for that, even though the policy covers the defense?
No, and Jones held that that's a contractual obligation that's within the coverage.
Within the
of
coverage, so you
policy,
should have
and
to
it
pay
meets-
those
meets
fees.
that
So what you're
definition of
saying,
covered claim.
what you're talking about is first-party claims where there's a denial of coverage and you have to sue your own insurance company, not for defense of the claim, but for the benefits.
Correct. And the legislative history bears that out. It basically said, this was back in 1977, that FIGA was automatically being held responsible for these fees and people were seeking to recover them. And the legislature wanted to limit the recoverability of fees based upon the actions, affirmative actions of FIGA itself.
Let's go,
other than
okay, so
delay.
in this situation, though, if the, 627.428 applies to FIGA, but only if it says deny by affirmative action. What does that mean?
If they deny a claim, there have been several recent decisions, I think we may have cited
Well,
was.
isn't this, the claim that was presented to FIGA was the claim for the attorney's fees that had been previously incurred? And they denied it and said it wasn't within the scope of their obligation, correct?
Correct.
So if the decision in this case is that it is within the scope, then you'd be responsible for additional attorney's fees, wouldn't you?
If it was in the scope of the
Right,
policy,
so I'm not
then
sympathetic.
they're not relying upon 627.428. If it's within the coverage of the policy, we're obligated because of the definition of
I'm
covered
just not
claim.
seeing, and I understand others may have different views, that 637.70 gets you there. So let me go back to the one that I think is either the stronger argument, and you tell me if it's plain language or it's ambiguous about that this is, whether this is a covered claim or not, that is, the prior claim for attorney's fees.
First, we believe that the term that's used in the statute, the three elements of a covered claim means it's unpaid claim. It arises out of the insurance policy. It's within the coverage of, and in this case, that's the key.
Well, it is
and it's
within,
not
okay,
an
but see, here's the problem. It is within the coverage because just like Justice Lewis was saying, the coverage could be, that it's somebody, it's a defense lawyer that was defending the insurance company and they're supposed to get paid. Can they get, and they are asking for fees not under 428, but they didn't get paid. Will FIGA pay for the defense lawyer who didn't get paid by the insolvent insurer?
Well, they would not have the defense lawyer that didn't get paid would be a class, as I understand it, under the receivership statute, it would be a class 6 because he's not, there's no contract between the insurance company and with respect, the contract that's being breached is not the insurance contract, but the employment contract between the insurance company
so it's not
and the
a covered
insolvent
claim.
insurer.
Then that would not be a covered claim.
That's slightly different. But
Is
if
that
the
correct?
insurer,
That's not a
correct,
covered claim?
Correct, that's not a covered
Okay,
claim.
so how do you then, and again, maybe it's an inartful drafting, including one of unearned premiums, if that was not in there, including one of unearned premiums, would unearned premiums be a covered claim?
Unearned premiums are a covered claim, whether they are specifically included in the policy.
Well, how does it arise out of and is within the coverage of the policy?
From the
Isn't a premium
set off-
separate? It's what gets you the policy. It doesn't arise of and within. It's not within the coverage of the policy.
Correct. It's not going to meet those three elements. And I agree, it's somewhat awkwardly worded. What's between the two commas if you were dealing with grammar, probably could have been put at the very end of that
Well,
sentence.
doesn't that
because-
create a problem, though, for the drafting of this, because it wasn't placed where it was, that whether including one of broadens the term covered claim. And again, I'm more sympathetic to your statutory construction argument, but I'm struggling, and so I want to understand somehow that throwing that one of unearned premiums in, I'm not sure if that helps or hurts FICA.
Why that was important is because it's not included in that specific remedy is usually a statutory remedy where unearned premiums have to be given back. It's added in there because under the liquidation orders, and which are pursuant to the receiver statute, these policies within 30 days of the declaration of insolvency, all of the insolvent insurers' policies are, if not sooner canceled by the insured, are going to be canceled, and replacement coverage has to be located. The statute and the legislature wanted to make sure, as they do across the country, that that money goes back, that's left on that policy, the unearned premium goes back to the insured, and they didn't want a situation where, since it's not technically within the coverage of a policy, that unearned premium would not classify as a covered claim. That's why it's thrown in, to make it clear. And whether it mentions it in the policy or whether it's by a statute which requires that, it's going to be considered a covered claim and it would be paid. And that's as consistent because that assists the unfortunate insured in securing additional coverage to carry out the remainder of the term. And I think where we started, it's I was listening to the previous argument, and we're dealing basically with plain, unambiguous language. So I agree, it was a very interesting brief, threw in a lot of different twists and turns, but in reality, this is a very straightforward case. Separate and apart from, as we've discussed, 631.70, it's the question of, do the attorney's fees under 627.428, are they within the coverage of this policy? They concede it was not. 627 doesn't make attorney's fees coverage or benefits under that policy, like, for example, the UN example. FIGA would have, that's going to change the coverage of a policy. If the insolvent insurer's policy doesn't comply with the PIP statute, the statute, that policy, by one of the statutes they cited, is going to be reformed, and it will be read as if it includes within the coverage that statutory mandated coverage. There's nothing you'll find in 627.428 that says the policy has to be amended so that it provides coverage for attorney's fees. And I can't make it really any simpler than that, and the legislature has spoken, and from a policy standpoint, if you increase the operating expenses, then the only people that are ultimately going to bear the burden of that are the Florida citizens and businesses that purchase insurance, because assessments will go right through the insurance company, and by statute they can pass those on to the consuming public. And we would request that this court approve the decision of the second DCA in this case. Thank you.
I want to focus on the 631.54 covered claim definition. First, it's ambiguous. They just said that unearned premiums aren't within the coverage, but yet they're covered claims. If you read the plain language of the statute, the which clause modifies unpaid claim and unearned premium. So if an unearned premium doesn't arise out of and is within the coverage, it can't qualify. Second, I've heard analogies to the liability cases. I'd like to point the court to an analogy to workers' comp cases. Since 1980, Florida courts have held that worker comp fees are covered claims under 631.543. And that's a much closer analysis to this, because there the worker is adverse to the carrier. You can sue the carrier in workers' comp. It's like first party. And under 440.34, whether or not the policy says it or not, if the worker wins, he gets his fees. And since 1980, three district courts of appeal have held that workers' comp fees are a covered claim if incurred pre-insolvency. And the legislature has done nothing to change that. And the sky has not fallen, even though workers' comp fees are a covered claim. And to address sort of the policy argument here, what they're asking you to do is, you're right, FIGA ensures that whenever we have an insolvent company, that the risk of that insolvency is spread through everyone in the state. It goes through FIGA, then they assess the insurance companies, and then they turn around and certainly assess their policyholders. If you didn't have that, the risk would be borne only by the policyholders of the particular insurance company. The few insureds in the state would bear all the risk. And if you read, I'd encourage you to read the Sturdivant amicus brief. It explains how if you don't allow these fees to be covered claims, it means that homeowners whose homes are lost in hurricanes are not going to be able to rebuild their homes, because the attorneys are not bearing the risk here. The attorneys are going to get paid one way or the other. They're going to get paid on a contingent basis or from FIGA. And if the attorneys have to get paid on a contingent basis, the homeowner's not going to have enough money to rebuild their home or whatever other loss they may have had. So I would ask the court, based on the arguments presented in the brief, to reverse the decision of the Second District Court of Appeal, find that a claim for pre-insolvency fees is a covered claim and not barred by 631.70.
We thank you both for your argument. That's the final case on today's docket. The court will now stand adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.